Hello, hello. My co-host isn't here just yet, but he will be shortly. What we're doing today is we're going to be looking at some of the legal arguments around Roe versus Wade, and we're doing this in kind of a different format from how we've ever done it before. What we're going to be doing is first today we're going to be looking at some of these legal arguments having not yet done a bunch of research, and we're just going to have a first reaction to them. Then over the upcoming week we're going to do research off stream and then do a follow-up episode um, next week where we talk about what we've learned and if we've changed our minds about anything. So let's see. Sorry, I didn't have much of anything planned before my co-host shows up, but he should be here any minute. Um, so we did one previous episode on Roe versus Wade, but that time what we were doing is we were talking about what we thought the political implications of it were. Um, I think both of us are coming into this having somewhat of a pro-choice bias, to the best of my knowledge. We're both roughly center-left type of people, and we're not going to be able to do some completely, unbiased, neutral analysis of the topic. Hey, what's up?
Hey,
Um, okay, so yeah, I was just announcing what we're going to be doing today. We're going to be looking at some legal arguments around Roe versus Wade just as lay people. Then we're gonna do research over the following week, and then do a follow-up episode next week about what we've learned if we've changed our mind about anything. Is there anything I missed? Anything you want to add to that?
nope, that was a pretty perfect summary.
All right, cool. Um, yeah, and this is Flowtrace, by the way, for anybody who's not familiar with him. Do you want to announce yourself?
Hey guys, I am Flowtrace. You can check me out at twitch.tv/Flowtrace and twitter.com/Flowtrace_. And every Wednesday, right here on twitch.tv/CricketStyleJ.
Yeah, we do this show weekly. He's been a wonderful co-host. Okay, so you got I think a video that we're going to be reviewing today. Is that right?
Yep, I've got I think it's one of a couple different back and forth that Destiny and Pisco have had on Roe versus Wade.
Okay.
Um, and
It just like occurred to me. Like, we probably can't show Destiny on camera, right? With him being a
that
banned
has
person.
also just occurred to me as well, now that you mention it. Well, shucks. That is a really good point, Cricket. I did not think of that.
You know what though? I remember you were saying that Pisco's done a few different arguments around this topic, right? So
Yeah,
so I I
I know
bet
I know that Destiny has hosted a bunch of them, though. I don't know how many that he has done that aren't on Destiny's stream.
I know he's at least done one where he was on Prime.
Yeah, here, let me see if I can find one of these.
And like Pisco does have his own stream, but I don't know if he like puts any of that stuff on YouTube or whatever.
That's what I'm thinking as well here. Although, yeah, let me just see if I can find.
I I should have thought to ask you that last night, but I just
No,
didn't.
yeah,
I
I should have thought to realize that ahead of time. Let me see if I can find. Okay, let's see.
Yeah, and Twitch with their slightly overly stringent bans. And
Yeah, this is probably the one time where we can't be like, "Oh, these rules are just too arcane. How was I supposed to know?"
we reviewed a debate of Destiny and Lauren Southern before, but that one we weren't actually showing the video. So yeah, I don't
Okay,
know.
here we
This is
go. I do have some Roe versus Wade debates here from Pisco has. Let's see
okay.
here on his Twitch channel. Okay, here we go. Let's see if I can. Okay, and then let me stream this. All right, there we go. Let me know if that's working for you.
Oh yeah, it is.
Perfect.
So
Okay.
so this one, I think I've actually seen like half of it before, so it won't be
Hmm.
like completely like 100% first time reaction, but
Hmm.
yeah.
Yeah. All right. Yeah, this is Pisco and Lactoid. I'm actually a big fan of both Pisco and Lactoid. I really like their the way they go about things in on like these panels or arguments and stuff. So this will be a little bit more sort of throwing ourselves into the deep end, given that both of them are, I believe, practicing lawyers at the time of not at the time of recording actually, but I think Pisco at the time of recording for this is like a week out or something from being sworn in. But the point is, I think this will be sort of amplifying the effect of us going in sort of unprepared and and very uninformed, and
Yeah,
just
and
seeing how we
and
come out the other side.
we're doing this on purpose. Like we're purposely approaching it as lay people so that we can then go do some research and see how that changes our mind and follow it. Yeah.
Right? And then yeah, like I'm just gonna jump right into it.
Yep.
Between these two individuals who I'm really happy to have on Roe v. Wade. We'll be talking about like the case itself and whether it makes sense that it was decided the way it was. And yeah, and we'll do it from a legal perspective rather than a random asshole on Twitch's perspective, which will be new.
And
We don't
that's
try that
us,
on
random
much of my
asshole.
Oh
panel,
yeah.
but so I'm really excited. Okay, I'm going to introduce these two, and we'll get started. All right. First, we'll start with Lactoid. Lactoid, thanks for stopping by. Thank you for agreeing to do this. I was really excited when you two started talking about this.
Yeah, no, thank you. I appreciate you bringing me on. This is an interesting discussion. It is going to be very legal, I'm sure. So it's going to be um, maybe a side that isn't often talked about I mean, besides the last couple weeks, usually isn't talked about in Twitch politics. Normally is the ethical and kind of what, the philosophical justification of, life and all that stuff. But we got two legal minds here to talk about it. So that's going to be fun.
Thank you. Thank you. Next, a person close to my heart. My man Pisco is around. Pisco, so happy to have you around. Like, it's always a treat. When I saw this opportunity, I jumped on it. Especially to get you in your element, which like. Usually it's you versus other people who don't have an idea of the law, so it's a pretty easy battle for you. It was like a bit of a challenge for you. How are you? Yeah, are you excited to be here?
Yeah, totally excited to be here. Absolute pleasure, as always, Prime. Thank you for putting it all together. I feel like a lot of my conversations the last like week have been centered around Roe v. Wade and Casey and the legitimacy of the court and it's sort of its view on it. And so I'm super happy to have Lactoid to discuss with, and yeah, just glad to be here.
Okay. All right. So I'm gonna take myself off screen. Um, would you guys prefer this or
Oh
this? What do
no,
you like?
back it up, please.
Okay. All right.
Thank you.
Gotcha.
I
All
agree.
right. Fanatic does it the other way, so I don't know. I've been
Can
thinking
you give me
about it. All
one
right.
second to get an
Uh,
iced tea though, Prime? Would that be too much
sure.
to ask for?
Okay.
Okay.
Oh no, go ahead. Yeah. All right. Then I'll put myself back. That's great.
That won't fly in court, Pisco.
Yeah. All right. I a few months ago, I served on a jury, um, and uh, like the defense, um, like the defense was the lawyers did not make a good impression on the judge, and oh man, the judge. I remember the judge like giving looks at the defense lawyer, and I could see her asshole like clenching because I think by the end she was terrified of this judge. Like just multiple things just went wrong. It was a shame. Anyway,
It's so
we
scary.
yeah, it really is. It really is. But all right, I'll let you guys do this.
Should
So
we comment
Pisco, you're
on
for the
that?
pro
Just like
side, so
That's right.
I'll
on
let you go first.
the whole idea that legal cases seem to be decided quite a lot on just the arbitrary, like, maybe I shouldn't throw in the word arbitrary, but just like the personal interactions between whoever happens to be at the court and whoever's arguing the case. It seems like um a big part of it is just dumb luck.
I think it is regrettable that that sometimes personal relationships between like lawyers and other officials, not to imply like a level of corruption, but I mean
Right.
it is entirely understandable that much like any industry, the law, there's going to be working relationships there. It is somewhat regrettable, but I think it is pretty unavoidable. And when it comes to problems with our legal system, it's pretty down on the list for me compared to other things that I think are currently a problem.
Yeah, I would have to agree, but it's just like
It is one of those things where it's just like, when you really think about it, it's a little weird.
yeah, exactly. It's just, even if you had, I mean, I don't know how many people in the country are qualified to be a Supreme Court justice, but you could imagine it might be 1,000, and then you just happen to have, like, if you just picked any 9 of them at random, you're just going to get wildly different outcomes depending on which 9 you pick, and then so I don't know.
Mhm.
Yeah, sure. So, about 50 or so years ago, Roe versus Wade was decided in a line of cases, I argue, that have to do with one's individual right on the fundamental decision to bear or beget a child. The court had, in the years prior, um, found that through the 14th Amendment or through other aspects of our constitutional system, that individuals have implied rights under the Constitution. Among these include the right to be um, able to get contraception, the right to raise your children the way you want to, teach them the languages you want to, the right to be free in many cases from forced sterilization. And that was not a controversial view of the court. It was in line with the decision of multiple justices over the course of many years. It made sense given the structure of the Constitution. The Ninth Amendment, for example, seems to imply or seems to understand that there is going to be such an exercise as looking for implied rights somewhere in the Constitution. It is in line with our incorporation doctrine, where we are applying the Bill of Rights as to the states. And so at the time, Roe versus Wade, which recognized an individual right to abortion, was in line with what the court was doing at the time, which is trying to understand what implied rights existed under the Constitution, and to see what the limits of those rights were. Now, two things. The court had made a couple missteps in the past in terms of finding implied rights where nowadays we would recognize there are no implied rights. This is the Lochner era of economical substantive due process, where the court was, I would say, improperly finding implied rights in the domain of economic regulation. But that didn't undermine the entire exercise. And there really is, I think, something to the notion that the Constitution recognizes, even if not explicitly there, certain rights. The second thing that I want to focus on is that Roe versus Wade represented a recognition that individuals and their governments are not necessarily that this relationship is not one that can be transcended easily. And so I think that it's important for us to recognize the due process rights of individuals and the interests of states, yes, in acknowledging those rights and sometimes overcoming the individual rights, but yeah, that this right to abortion exists, that it's consistent with precedent at the time, and that the stare decisis factors for overturning Roe v. Wade point solidly in the favor of maintaining it.
Okay, Lactoid, please.
Gonna pause there. I thought that was a good opening. I think we're already starting to see, or at least for me, I'm already starting to get a little lost on exactly what he's saying. I thought the first argument he makes, I think I'm following pretty well, just the idea that, the Constitution doesn't explicitly describe every particular right that it still protects. But in the second argument seems to be a much more tricky one. I think Lactide was actually having a somewhat of a reaction to the argument as well. I'm not exactly sure what he's trying to say when he talks about like the due process of people. Yeah, I guess in application of any law that would restrict this, basically the idea that like if you were going to restrict abortion, that would necessarily the enforcement that would necessarily like violate people's rights in some sort of way, like it's almost unenforceable while being constitutional.
I don't quite follow that part either, but I'm just like taking notes while we're watching this. He used a term there that a lot of people are probably not familiar with. It's stare decisis, and so this is spelled STAREDECISIS, and it's some kind of Latin term, I guess. And I'm trying to remember. I've looked this up before. I think it's something along the lines of like, you know what? I should just look it up right now rather than try to remember
Yeah,
whatever.
my assumption would have been that would have been some case.
No, okay. It's the legal principle of determining points in litigation according to precedent is what it is.
Okay.
Yeah. So basically, I think what he's trying to say here is because they've previously established the right to bear and beget a child, for it was supposed to be constitutionally protected by both the federal government and the states. Then they go into Roe versus Wade wanting to respect that precedent. I think that's what he's saying.
Okay. Yeah, I think that follows because I think what Pisco is going to try and make the argument is that like this is constitutional insofar it's that the enforcement would necessarily infringe on the freedom of people to decide how they want to raise a family.
Right.
So, all right, mine's a little bit might be a little bit longer, but I'd like to start off my opening with a quote of some of the legal reasoning from Casey versus Planned Parenthood, which is not Roe, but it's a case that came after. So this is from Casey. At the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life. Beliefs about these matters could not define the attributes of personhood were they formed under compulsion of the state. So, despite this rock solid legal analysis from Casey, I'm a little bit black-pilled on kind of the entire legal framework here. I just want to start out by saying my personal conception of rights is incredibly different than my understanding of how the law exists and how the process of law should exist. I think that the bad with the law in this country goes back to vague laws, right? I do agree the Constitution should be broader and it should be more specific and it should protect more rights. Personally, I am firmly, morally in favor of the full legalization of gay marriage, gay sex, bestiality, necrophilia, and the full legalization of all drugs. That said, I'm skeptical of partisans interpreting the Constitution to flex the law into what suits the political zeitgeist of the heyday. It should be done the right way because I'm against hacks bending the Constitution to fit their dastardly intent, like Korematsu, right, protecting race-based concentration camps, Wickard, which allows the feds to do anything, Chaplinsky, which decided that freedom of speech doesn't exist when you call a cop a fascist and he beats the fuck out of you because, well, them's fighting words. Or, which I think is going to be a relevant case, it's going to be brought up several times here, Scott v. Sanford, which, like Roe, had horrible historical analysis to interpret the Constitution in a way that it was not written and could not reasonably come from the founding. in order to determine black people can't be American citizens. In contrast, originalism is the belief that legislation must be interpreted from the position of those who wrote it, not what we can twist it into now. This is the fundamental idea of originalism. The judicial branch is intrinsically conservative, a status quo branch of government intended to protect from government overanalyzation. You know, Lochner was brought up. In my personal morality, Lochner is fantastic. The horsemen were sick, right? They protected classical liberalism, they protected libertarianism. But I'll be honest, they didn't have the best grasp of the Constitution. So I think we have to go over the cases that, and I'll just admit these because I'm sure these are going to be brought up. These are the cases that I think are weak, right? All the cases I've already mentioned, every case affirming Civil Rights Act over private citizens, Obergefell, Lawrence, Griswold, and yes, Roe v. Wade. Roe is faulty for several reasons. Bad historical analysis, a claim not to be determining when life begins, when it sort of explicitly does and definitely implicitly does, and ignorant of the attempt of the drafters of the 14th Amendment. Its trimester framework is broken, and they had to patch it up with Casey, but the underlying problem remains. Alito's decision was coming from a mile away. Roe was weak, Casey was weak. They're inconsistent. They provide no justification for the trimester framework in Roe or the viability lines in Casey. They just assert it abstractly. This was recognized the day it was ruled. Many Democrat politicians pushed to make abortion protection legislation because even they knew Roe was fucked. Ultimately, we can argue all day about whether or not this is a good decision, which I think we should because it's fun. But SCOTUS has the authority to do two things. A, overrule SCOTUS, and B, interpret the Constitution. Now, I understand, Pisco, that one of your main arguments here is, stare decisis. But while it can be, I guess, persuasive for the Supreme Court, it's not actually, it doesn't have, they can overrule it, right? I mean, look, Casey overruled major parts of Roe. The two abortion cases are in conflict, and one is the Supreme Court directly overruling itself, right? Casey is overruling the stare decisis of Roe, and yet Casey is one of the abortion cases that is supposedly guaranteeing the legal right to abortion. Roe never even specifies where in the Constitution it's getting its logic from, right? It never specifies what undo means. Under this line of reasoning, Alito's decision could just simply say, fuck you, abortion is legal across the board because 14th Amendment protection of life. And you might think that's ridiculous, but I mean, argue against it, right? Why couldn't the court say, we decided we can protect life of persons under the 14th Amendment? Obviously, the court defines persons to some extent, and the court could define a person as a fetus because there are, going back, there are laws criminalizing killing a fetus as murder to this day if it's not the mother. And the people at the time of the 14th Amendment seem to not like abortion too. So, and they were passing laws, therefore, federally, we can just make it illegal too. So now you can't abort. I think that the experts who didn't see this coming suffer from what I call law student syndrome, which is that what they think, whatever is said by their lib con law professor is unchallengeable. I assert living constitutional theory is arbitrary, obviously politically motivated, and that originalism is the only actual structural legal theory. Instead, we live in under the hellscape that is living constitution theory implemented by FDR and his fascist court of clowns, and means that essentially the Constitution doesn't matter. That said, even though all this is fake and arbitrary under living constitution theory, I think Roe, even by that standard, is extra fake and arbitrary, and I look forward to arguing that position.
Good to go?
All right, please.
I'm curious, Lactoid. So you do not believe
you
in implied fundamental right?
Yeah.
Okay, so at first I was a little bit confused about what Lactoid was saying here because he started off by saying something about how like the Constitution needs to be like broader and more specific, and that seems like really unintuitive to say both of those things. But I think I get what he means. It's just he needs. I think he wants these laws to be defined in a more specific way and to be like laid out more thoroughly. So it's not actually contradictory. And I think it makes sense why he would want that if he really does believe in originalism, then you would want, if you're taking every law at face value and not wanting to use any implied rights, then you would want to be very careful to actually spell out all the rights that you would then want to use in court cases.
Yeah, I think it's really interesting that I think Lactoid is going after sort of the principle by which Pisco is saying that this decision can be justified, and saying, well, couldn't you take this to other extremes? I thought that was really it's an effective tool. I'm just surprised that it's being used as opposed to just sort of going after the legal principle at its core.
And when you say the legal principle, you're talking about the principle of like implied rights. Is that what you're saying?
Well, I'm not entirely sure exactly which legal principle he's trying to get at. That's sort of why it was a little surprising to me is when he says, Pisco, by this decision, couldn't you make a decision about abortion, for the entire country that, it's just totally banned. If that's true, then that is something that Pisco needs to respond to. But it strikes me as something that would be made. It strikes me as a kind of argument like someone would make against Pisco in like a panel, as opposed to the very sort of like rigorous like lawyer debate. Not to say that it's a bad argument. I think it's a good one. I was just surprised that it went after more sort of like the practical application rather than like, and maybe this is just my own misunderstanding of how some of these legal arguments have. Maybe I have them like on this like I have them like on this raised pillar in my head, but I just would have imagined it would have been much more like going after, this principle by which you think that we can extend this implied right is wrong for these three reasons.
The way I took that to mean, it sounded to me like he was saying, like, I have the one right interpretation of the Constitution, and you're just making up stuff at random. So if you can just make up that at random, then why couldn't you just make up
Hmm.
something else at random? I mean, that's kind of how it came across to me.
Okay, no, yeah, I can see that as well, actually.
I think that there are implied unenumerated rights of the Constitution, but I think that when you have a situation where, like, I think you have to go back and again, so you don't get crazy with it, you actually have to look at what was the intent and the acceptability of what was being drafted at the time of drafting of that particular.
So to be clear,
legislation.
you agree with substantive due process as a legal theory?
Could you and I'm asking this because I haven't heard a very firm definition here from anybody, even in law school. So could you just please describe what you mean by substantive due process?
The notion that the 14th Amendment embraces more than just procedural protections, that the 14th Amendment is a source of implied fundamental rights, that among these are I'll just leave it there and then let you answer that.
I'm skeptical of it. I could accept it if it wasn't so glaringly in the face of something that wasn't accepted at the time, right? So I can understand there could be a theory of, well, we're faced with a new situation that we've never faced before, like let's say computer privacy or something, right? Or something that just simply couldn't, because of technological limitations, couldn't come up at the time. I could see, us taking a look at that and say, well, based on the writing here and the interpretation, right, they very well could have meant it to apply to this, right? But at the time of the drafting of the 14th Amendment, historically obvious they did not mean for it to apply to abortion. I think you would have to admit that.
I'm not going to get to abortion yet. My curiosity is whether or not you think that the 14th Amendment is a source of any fundamental rights for individuals, not just procedure.
I think it could be. I think it could be for things that were not decided at the time. I'm unconvinced.
Things that were not decided at the time.
Yeah, things that were not obvious at the time, right? So when you have the 14th Amendment being drafted in a time which was so obviously against abortion, I think it'd be dishonest to assume that that's something that they even could have meant by drafting it. Now, could you make the argument that they actually meant it for new situations today? I would hear those arguments, and I could agree with some of them. But for abortion, it's not a new thing.
That's odd. So the 14th Amendment could be a source of implied rights for new phenomena not found.
Mm-hmm.
Because they're talking so much about the 14th Amendment, I actually think it would probably be a good idea for us to just look it up and read it right now. Just
yeah, sure. Let me.
Because I remember I've looked this up before, and it's not super long, and we can just get the text and I'll just have it here and we can look at it. Oh, actually, never mind. Well, it's a little bit long, but maybe it'll take like 3 minutes to read this or something. All right, so here's what it is. Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Okay, you know what? Like, I'm not even sure we need to read the, the rest of this because
Yeah.
to me that sounds like it's just straightforwardly protecting the rights of individuals. I don't know. Do you think there's
Mhm.
any ambiguity in that?
It seems, I mean, it's certainly not at first take, right? That seems pretty clear right off the bat.
Yeah, it does too. Oh, you know what? And actually, like the other sections don't even seem particularly relevant to this. They're just about like reapportioning the senators and representatives and the national debt and stuff.
Mhm.
So I think
Yeah.
section 1 is probably the only relevant section.
Just
Yeah,
commenting on the actual back and forth here, I think that both Pisco and Lactoid are doing a really good job here. Pisco's, very obviously trying to set up the building blocks of his legal principles, which, he mentions, I'm not even getting to abortion yet, I think clearly he's setting up principles by which you would then naturally come to the conclusion that, you can't ban abortion. And Lactoid, and then to Lactoid's credit, I think he is, very clearly signposting, well, hold on a second. I might agree with these principles abstractly, but the application of that might change, and I know that the application we're getting to is abortion.
yeah. So, and that makes some amount of sense that like perhaps when they originally wrote the 14th Amendment, they probably weren't thinking it had anything to do with abortion specifically, but it seems to be written in a really broad way that um, to suggest that that like the states can't violate rights that the federal government can't violate. I mean, that just seems to me like the pretty obvious reading of the text.
Mhm.
So I don't know.
At the time, it would seem to counteract the kind of originalism or focus on history that seems to be the bedrock of Alito's opinion. And if indeed I'll leave it there. Well, what do you think about that?
I disagree.
What do you mean? I mean,
I,
you've just told me that the 14th Amendment is a source potentially of fundamental rights, but only for new phenomena not known to the founders or not known to the framers of the 14th Amendment, I suppose.
Yeah, if it follows the exact same kind of like fun, if it shares some of the fundamental elements of things that it was applied to at the time. So, um, I can't think of like a great example off the top of my head, but if you have an example of something that's
Oh,
just
actually,
come
can you
in,
pause again?
that's sort of a modification.
This seems like a really interesting distinction between originalism versus literalism, right? Because usually if I hear those two terms used, I think of them almost being like synonymous. But I think this is like a really specific case of them being different because I think the interpretation I was taking reading that section of the 14th Amendment was literalism, whereas he's going with originalism but not literalism.
I think, yeah, it's really interesting that Lactoid is saying that he considers it's a really tricky argument, just logically to understand. I think to say that the 14th Amendment is a source of fundamental rights, but the ways in which it is a source of fundamental rights we can already see as having been defined by the originalists, and their application speaks to how we should interpret their words, because
Yeah.
clearly they meant it in this way if they used it this way, and thus we can tell what their intent actually was by what they did. That's a really interesting argument. I
Yeah.
actually really like that. That's really
This is
cool.
not what I'm used to hearing from conservatives because most of the time when you hear about conservative legal interpretation, or at least maybe I shouldn't say most of the time, but I've often heard them talk about gun control in that we should interpret the Second Amendment to include weapons that they hadn't invented yet, hadn't even imagined yet, but Lactoid's doing the opposite of that. Like it seems like if he took this same stance toward the Second Amendment, it would be like, well, it just protects your right to have like muskets and knives or something like.
Yeah, I think. Well, I think there is a slight difference there in that Lactoid, and I think he just got at this, is that he can see, if we can equate a new phenomenon now to one previously, then we can sort of bring forward their treatment of the previous phenomena to the one that's very similar to the current phenomena. So, like, Blacktoid would say something like, they didn't have AR-15s, but like their muskets were very analogous to our AR-15s. So we should probably treat our AR-15s in a way that is very analogous to how they treated their muskets.
Yeah, I suppose. I mean, I would have thought that if you're just going with original intent, that if they like, okay, that's a plausible interpretation. Like, if you're trying to go with original intent, that if they said right to bear arms, perhaps they meant like all armaments, including ones that we've never seen before. It seems to me like if you took that same thing to the 14th Amendment, then and you say that like here, let me go back to the text and see exactly what it said. It says, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States." I mean, shouldn't that then include privileges and immunities they've never seen in much the same way that the Second Amendment would include weapons they've never seen?
Yeah, I I think the argument that I think maybe Pisco shouldn't go. The argument that I would go after, not to say that Pisco should or shouldn't do this, because Pisco's probably got a much more cohesive view of what his argument is. I'm only 15 minutes in. Is I think Pisco should ask the question of, do you think that there are contradictory views within the worldview of the framers? Um, and
Well,
if so, how do we resolve those contradictions? Because if you're saying we should just we should consistently apply the intent and basically the worldview of the people who wrote the 14th Amendment, well, what about when that worldview is contradictory?
yeah.
Like, a great example would be like slavery, right? How, setting aside the fact that obviously, slavery was morally repugnant and was awful and evil and horrible, how do we interpret, uh, the like verbiage of things like rights for people and stuff like that, given that like it seemed like this was still an open question even between people at the time and that their view was very contradictory.
Yeah. I think that's a really good question. I mean, first of all, even like a single person can have contradictory views, but the founding fathers are not even close to a single person with a unified
Yep.
worldview. It's a big group of people with lots of different opinions, and so
And
like
conflicting views often.
yeah, and conflicting views, and like literally fighting each other to the death over those conflicting views. So if you then want to say, this kind of thing that we should interpret laws according to what the founding fathers meant, while they themselves couldn't even decide what they meant, it's like a little bit rough.
Hmm.
Of a prior, well-established, unenumerated right of the 14th Amendment at the time. I mean, that's
Okay.
something
So,
that I would
but
consider.
at least you agree that the 14th Amendment is a source of unenumerated, non-textually based rights. Is that correct?
I don't have a firm opinion on that. I would be open to the argument.
Wait, isn't one of the big objections to abortion on Roe v. Wade that it's not textually found anywhere in the Constitution?
So my objection here to Roe v. Wade is that, but again, the reason why I have such a strong opinion on this in particular is because that it's combined with the fact that at the time of the drafting of the 14th Amendment, there was widespread opposition to this, and obviously, if any kind of honest historical analysis, you would see
That's
that they did
you.
not intend it to
Yeah.
apply to that.
Excuse me. That's
Their
you.
intent, their originalist intent, did not apply to that.
That's
Obviously.
you taking it one level down the road. That's you applying, assuming that there could be such a thing as a fundamental right in the 14th Amendment, and then having some kind of analysis to distinguish abortion from other stuff potentially. I'm asking you one level removed, and what you're telling me is that you don't have an opinion on whether or not the 14th Amendment, is a source of unenumerated rights. That you're agnostic to that fact. That you don't have an opinion on.
Yeah, I mean, yeah, so I'm somewhat agnostic. I think either way, Roe is trash, right? If I strongly do, obviously Roe is different because at the time, they were not in favor of abortion when they drafted that. And if I don't, well, if I'm not in favor of unlimited rights, then obviously I'd be against Roe v. Wade on that basis
Well,
too.
this distinguishes you from Justice Alito and his draft opinion, wouldn't it? Because you would agree that Justice Alito's opinion does acknowledge that substantive due process and implied rights are the law of the land.
Sure.
Okay.
Yeah. I mean, I like I said, when it comes specifically to the unenumerated rights implied by the Constitution that don't have to do with, like, that have to do with new scenarios. I guess one of the issues is I can't think of like a very firm example. But
how about this? How about the
I'm
incorporation doctrine? So that you must acknowledge the Bill of Rights, Second Amendment, First Amendment, all these wonderful amendments as originally thought when they were passed in, I don't know, 1801 or whatever, whenever it was passed, 1791. Those did not apply to the states. You agree with that premise?
My understanding is that's true, and then the 14th Amendment in 1868 is what made it apply to the
doesn't
states.
say, the 14th Amendment doesn't say that. The 14th Amendment has been understood that there's this implicit concept of liberty where it's a source of substantive rights, and that's how we get to the First Amendment applying to the states. You're not bringing that doctrine into question, the incorporation doctrine, are you?
So, well, I disagree when you're saying that it doesn't specifically state that. I'm reading the 14th Amendment. I think the language is pretty clear, and I think it was understood at the time and intended by the founders to apply to the states. That was part of the reason of drafting
to apply the
because they
Bill
wanted
of
to
Rights
avoid
to the states. You think that that's explicit in the 14th Amendment?
I'm reading it here. I think it's both. It's pretty clear based on the text, and especially clear based on what their intent was in drafting it. Again, the originalist perspective. You go back to what was the purpose of this? Part of the purpose of this was to apply the Bill of Rights to the states.
But what is the language you're pointing to? That the state shall not deprive individuals of liberty without due process of law? That is the source for interpreting the Bill of Rights to apply to the states. That's a rather odd way to say that we're going to apply all the Bill of Rights to the states.
No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law.
So where would you find
production of law?
Where would you find the incorporation doctrine to be properly sourced from? The privileges or immunities clause of the 14th Amendment, or the due process clause of the 14th?
I think just a little bit of both. I think the privileges and immunities clause, I think, is probably a big part of that. But I think it's probably a mix of both.
Is it an essential?
And again, I think the element. I'm not a pure textualist here. I think you have to look at what the intent was of what they were getting at with this amendment. I think that was also an essential part of the analysis here.
It seems odd because if the privileges or immunities clause applies to citizens of the United States, and as you know, the due process clause of the 14th Amendment applies to people, and so it would seem weird to say that it's a little column A, a little column B. They're addressing different groups of people. So how can it be that this incorporation doctrine, don't you have to choose? Why do you say it's both the 14th Amendment and, both the privileges or immunities clause and the due process clause?
I don't think it's a contradiction to say that they both apply. My question for you is, do you agree that the 14th Amendment was intended to apply to all the states? To extend the Bill of Rights to all the states? Do you agree that was the intent of it?
I do so unabashedly. Well, I'm not an original intenter.
The intent, but like, let's put yourself in the originalist shoes for a second.
Mm-hmm.
Do you agree that that was the original intent?
No. You think the original
really?
You think the original intent of the people who framed the 14th Amendment was all the Bill of where all the Bill of Rights are applying to states?
Yeah. I mean, maybe it's a different legal analysis we can take a look at. I think that applying
the Bill of Rights,
historical
evidence
rights and privileges. I mean, I'll have to do a lot of research to actually bring up the treatises and shit on that. But that's my understanding of the 14th. Part of the idea of the 14th Amendment was to apply, is post-Civil War, right? It was to apply the Bill of Rights to every citizen in the United States. So you couldn't have states that were, coming up with their own religion or coming up with their own, specific policies that were an abridgment of the protections granted by the Bill of Rights.
That's read into the.
That was the intent of it.
You can say that's the intent. What you're telling me is, well, there's some treatise somewhere that provides historical evidence that, I don't know, the people who drafted it thought about it.
Listen, I've been at a law school for 2 years now. I didn't specifically research that specific section before.
But you are not denying that has to be read in. You'd agree it's not explicit. That's something that you need to. Those are implied rights.
So it's not implied. It's a historical analysis, right? So it's not just about like we read it and then whatever somebody today thinks it means is what it actually means. It's about taking a look at it and then doing a deep dive into what was the purpose of this, right? And when you have a situation in which you have a amendment like the 14th Amendment being crafted at the time in which there is, already before the 14th Amendment and immediately afterwards, a massive shift towards pro-life agenda. I think you have to acknowledge the 14th Amendment had nothing to do with that. Do you at least agree with that? The 14th Amendment at the time of drafting was not intended to apply to the abortion debate.
I agree that it not to the specific policy of abortion, but of course we don't read those rights that way on the policy level. It's not meant to apply to a specific set of circumstances that existed in the 19.
I think when we're doing our research over the next week before we get to before we follow up on this, I suspect it's going to be worth it to just look up historical documents around the writing of the 14th Amendment and see if we can discern anything about what the people intended when they did write this.
Yeah, I'm not entirely sure exactly what Pisco is trying to get at with the question of incorporation of the Bill of Rights in regards to the 14th Amendment here. I feel like up to this point I was following pretty clear, oh, this is what Pisco is trying to set up. But here I'm not really sure exactly what he's trying to sort of set up to then get Pisco, or to then try and leverage against Lactoid as to why Roe versus Wade is a constitutionally sound decision.
Okay, I think I know what he means. I could have this wrong, but here's what I'm taking him to mean. So the idea would be that the Bill of Rights, the rights that it spells out for all the citizens, were originally just supposed to be restrictions placed on the federal government, that like the federal government can't restrict your freedom of speech, freedom of religion, and so on. But it didn't at the time apply to the different state governments. It was just only the federal government can't do these things. And then I think what he's saying is then that changed when the 14th Amendment happened, and now the state governments also can't violate those rights.
Yeah, okay, I can see that. I'm just not sure exactly where where that is then going to function in the broader argument.
I think I probably know the answer to this as well, which is that when Roe versus Wade comes around, it's because some of the state governments were trying to put restrictions on abortion, and and the idea is that if you believe that there is a federally protected right to privacy, with regard to your reproductive decisions, then the 14th Amendment is going to be relevant because it's saying that, like, not only can the federal government not outlaw abortion, but by extension, the state governments
Okay, yeah,
can't.
I see. It's sort of the latter half. If it is true that like the Fed can't, then like obviously it's going to be fine for them to. Okay, I got you.
I think that's what's going on here. Again, like, we are not legal experts, but that's what I think is happening.
Century.
So let me ask you this then, Pisco. So you're saying that it doesn't. So at the time, you agreed already that the 14th Amendment did not apply to abortion at the time of drafting.
No, that it was
so
not. You asked me, was it intended to?
Sure.
They did not intend it to. No.
Right. The people who drafted it, even though they were well aware of abortion existing at the time, because all these states were legalizing it, did not intend for it to apply.
That's correct. They also didn't. They
also
didn't intend. Just to be clear, they didn't intend to desegregate schools in the 14th Amendment.
Sure. Fair? So before we jump to Brown, I want to hold you specifically to this, specifically with abortion. Why is it that they don't intend for it to apply here, and so that doesn't apply there, and then 100 years passes or something, and then now all of a sudden it applies? Can you explain that constitutional analysis? Like, what is the constitutional significance of 100 years?
So we do not look to the origins of a fundamental right that's implied, in my opinion, just based on the particular circumstances that existed at the time of the ratification of the 14th Amendment.
Where do we look?
If that were the case, you would have to, which I guess you do now, and you've conceded at the start of your debate, you'd have to deny Griswold, you'd have to deny Lawrence, you'd have to deny all that entire line of cases. I'm assuming you'd have to deny the child rearing cases, wouldn't you? Where is this huge history for all of these rights? And I think that your style of interpretation, which views these things hyper narrowly, it's abortion qua abortion, as opposed to the decision whether to bear or beget a child. That's what's leading us there. This myopic focus on the individual set of circumstances. And just because they haven't, just because they haven't, they didn't at the time think about abortion when they were crafting the 14th Amendment, doesn't mean that.
No, they thought of it.
You think that they thought about it in the draft in the 14th Amendment? They thought
Obviously,
about
it
abortion?
was literally at the time of the drafting, right? Like just before the drafting, and up to 1905 is when we saw like the massive pushes for the pro-life
no.
agenda in the
What
United
I'm saying
States.
is in the
And the 14th Amendment, like despite the fact it was already there, the Supreme Court did not enforce this on the states. It was not intended to be enforced on the abortion question specifically. And my question,
the
I asked,
drafting
and
of
you agree that
the drafting of the 14th Amendment isn't like this history where people they considered abortion and then they rejected it at the draft of the 14th Amendment, correct? There's no like it wasn't part of the
okay. Okay, so there has to be, I agree with you, whenever we're doing any kind of historical analysis for any reason, there has to be some level of, I guess, good faith in analyzing whether or not, what is the reasonable application here. When you have a court draft the 14th Amendment in this political environment.
When the court draft or when the court draft?
Oh, sorry, when you have Congress and then you have the Congress draft and then you have the legislature, right? And then you have the court who now interprets that and applies that, right? Arguably, I would say they do apply it, and that's a civics lesson. But when they apply it and they interpret it, and up to 1905, like the laws just kept getting more and more strict and expanding across the states. And the 14th Amendment was not a block to this. It was not a contention.
You're hammering on the same
point
and you're repeating yourself.
Because you did. Wait, hold on. Because you didn't answer the question I asked before.
Which is what?
Right. The question I asked before was, you agreed with me this was not intended to apply to abortion, and now 100 years later, right, the Supreme Court intended for it to apply to abortion. What is the constitutional significance of 100 years? Could you explain that?
The constitutional significance of 100 years? Yes. I'm not sure.
It appears to me like Lactoid is misunderstanding what Pisco said. Do you get that impression as well?
No, actually, not really.
Okay, because he's asking like, what's the constitutional significance of 100 years? And I actually, here's, I don't think Pisco is saying that it now applies to abortion because it's 100 years later. I think what Pisco is saying is it applies to abortion because it broadly applies to a bunch of unenumerated rights, and that would have been true even at the time it was written, despite the people who wrote it, maybe it didn't occur to them.
Yeah, no, I 100% agree there. I think this is a misstep from Lactoid, because I think Pisco has a very good, easy answer from his worldview, from the worldview he's defending in this debate, which is just that there is no constitutional significance to the 100 years. It just took us 100 years to correct this problem. But this decision would have also been correct 100 years ago. It's just that they didn't make that correct decision.
Yeah. So this makes me wonder, like is Lactoid like misunderstand? Like, okay, like I guess there's a lot of different things that could be going on here. One, we could be misunderstanding what's going on. Another thing is maybe Lactoid is like misunderstanding the point that Pisco's made, or maybe he's heard other people make similar arguments that he's confusing with the one that Pisco's made. Or it could be that he's just like testing him rhetorically to see like, well, what is your response to the significance of 100 years? Because like that doesn't have to be a bad faith thing necessarily. It could just be like, do you think it matters that 100 years have gone by? And,
yeah.
Sure that there's a constitutional significance in a given lapse of time, other than our developing notions of, for instance, for rights that we think that are attached to this, evolving standards, things like the Eighth Amendment, that there might be some relevance in time lapse there. And certainly between, I think a good example is Plessy and Brown, you can see the fact that some decision doesn't seem to be accepted by the people, or the factual assumptions on which a decision is based don't seem to be borne out, or time has seen developments in the law. That time can be significant for that reason, but it's not the time, it's what the time has what insights it has given us. So another good example of that would be Lochner. The 20, 30 years, or I don't know, the 30-ish years between Lochner and, is it West Paris Hotel? Whatever the case was that overruled Lochner, that was significant, not necessarily for like the 30 years, but what we learned in those 30 years in the Great Depression. And certainly, if you're gonna, sting me with, well, what did they intend at the time of the signing, and you're gonna marry people to that, you got the answer for Brown.
I've already said, like, I mean, I haven't like fully like read through Brown, but I started off by saying I'm not a huge fan of the actual legal analysis there.
So Brown v.
I
Board
think
was wrongly decided.
Like I said, I haven't fully read through it. I'll have to read through it to see how much of like a complete arbitrariness, like they're basing off of like Roe is. But
let's just do the,
I
let's just
remember
do the analysis.
from what I recall. I mean, this is a Roe discussion. I mean, from what I recall from law school, I remember reading through it, and I'm thinking, wow, that some of the legal analysis here seems a little bit weak. On the Roe case in particular, I wanted to comment on the answer that I finally got, which was that the 100 years doesn't actually have much of a constitutional significance. I assert that the Constitution has a procedure for amendment, right? When you want to add certain things to the Constitution, there's a way to do that. And that is spelled out, specifically how to do it. And so when you have 100 years, even if it's 100 years, that doesn't mean the Constitution just changes based on things we have learned, right?
You're begging the question.
If it changes based on things we have learned, it's up to Congress, the people who have learned have elected to change it.
You're
right?
begging the question.
That's how the process works.
You're assuming that the only way to interpret the Constitution is by looking at the particular practices that existed at the time. You asked me.
It's the only good way.
Well, it's not the only way, and it's not been the history of this.
The only good way.
It's not the only good way. It's not been the history of this court. And to accept that at the time means that you have to accept Plessy. And you can get away with it and be like, oh, I haven't read Brown. But you know what Brown's about. And you know what Plessy's about. And you know what the Equal Protection Clause is about. And you know in the 1860s that when they passed the Equal Protection Clause in the...
I think it's probably worth us quickly looking up these other cases so we can summarize exactly what they are. I believe Brown versus Board of Education.
That's desegregation of education, I believe.
Yeah. I think that's right, but let me double check it.
I believe that's the separate but equal is not acceptable or possible.
Yes, you have that right. And then the other one he's referring to is Plessy versus Ferguson.
I'm not sure which that one is.
Oh, this is I guess the one that established separate but equal.
Okay.
This is from 1896. So I
guess yeah. This is the one that okay.
That's the one that got overturned by Brown versus Board of Education. Okay. That's also...
when you Google Plessy versus Ferguson, the top stories are results about how Senator John Cornyn says, "Do Plessy v. Ferguson after Roe v. Wade decision." Not a very good headline there. I am confident that Senator John Cornyn, though I may disagree with him, does not want the return of racial segregation.
I hope not.
Yeah.
14th Amendment, they did not think they were segregating schools. You would agree with that fact, wouldn't you?
Probably. 14th Amendment probably shouldn't apply to the other.
So you think Brown v. Board was wrongly decided?
If that's the central holding, if there's no other rationale besides that,
well,
then
what
probably,
other rationale would?
Go read it
okay,
again.
I mean,
I don't know.
I just want to say real quickly. I understand why PSCO is getting frustrated here, but I don't think Lactoid's the phrase that Lactoid should say is for the purposes of this conversation. Because what is effectively happening here is that Lactoid is being effectively a little Weasley, although I don't think he's intending to be. Lactoid is not being like, I'm going to leave myself open so that I can maneuver myself into debate. Lactoid is just genuinely not certain. But I think what he should do is, for the flow of the conversation, is say, listen, I just want to be clear that, that I have not looked into this enough to have a strong decision, for my actual opinion, but for the purposes of this conversation, I will take you at your word. But I just want to signpost that here, just so that everyone understands this is not, representative of my real true opinion in the way that everything else I say will be, because I'm uncertain.
But yeah, I agree. And actually, I think as frustrating as it is to ask somebody a question and just have them come back with "I don't know," I wish more people would do this, and like debates generally is just admit when they don't know stuff. So
debates especially, but in general, the willingness to be like, I'm not sure about that. Yeah, that is something that if people did that, we'd be in a way better place.
Yeah, also in general, but I think especially in debates, because it seemed like people just have their ego on the line in debates so much, and they're really reluctant to admit when they don't know stuff. So I want to toss Lactoid a little bit of praise here for just admitting that when he doesn't know stuff.
Yeah, 100%.
I've been telling you multiple
This
times.
is where
like,
this
I've
kind
read
of
a couple
analysis
cases
will
here.
get you. This kind of analysis, which focuses on the particular practices at the time of enactments, will, instead of focusing on the values that are essential in
Your values.
no, the
Your
values at the
values,
time.
yes.
The values at the time. You are absolutely, there is a lodestar. There are fixed things, but it's not fixed at the level of generality of the particular circumstances of the time. It's the particular value. And that
All
makes
right, so
total
Pisco,
sense.
I'm gonna do a little bit of because I know what you're doing, right? You're saying, okay, like logically speaking here, there's not a direct pathway, so you're just crazy if you disagree with Ford, right? Now or Brown. So I understand that
Is that-
tactic. I have to ask. Yeah, that's what I'm thinking is happening here.
No.
You know, I have to ask, like with Dred Scott, for example, like Scott versus Sanford.
Yeah.
You know, I have to, like, you know, would you agree with me that, I mean, it's a universally condemned case.
Yeah.
It's especially condemned by originalists because there's no actual basis for a lot of the historical arguments from Sanford. But it was a understanding of the time from the Supreme Court who was writing based on the experiences of people living at the time. Do you have any argument against Sanford from like a legal procedural point of view, or do you just think like the outcome is racist, so it's bad?
No, it was wrongly decided the day it was decided for many reasons. You know what? In that case, for
By the
instance,
way, that's the case that said
the court
that black people
Black people
could
are
not be
property.
citizens,
Yeah,
like even if
because
they
they're
were like
property.
even if they were like freed slaves, they still
Yeah.
could not be citizens.
Yeah, Dred Scott was I believe, was a freed slave who was trying to then leverage his status as a citizen in like a northern state as a reason for why he couldn't be like recaptured. And I believe the court decision was basically, well, because you are black, you are not eligible for anything, for any of these rights fundamentally.
Yeah. You got it.
took crazy steps in striking down the compromise, the Missouri Compromise, and taking what I would say is totally unprecedented steps in overstating its jurisdiction over things that were not even like up for discussion and weren't even before them. There were problems in also in terms of just reading the Constitution the way that that Chief Justice Taney, I think that's his name,
Myopic
was
Times has
reading
got
it.
it right in chat. It was not that he was a freed slave; it's that he was a slave taken into a non-slave state.
Oh, okay.
And then he sued, saying that because he was taken into a free territory, he should have been freed by the laws of the territory that he was in.
Wow, I did not realize that. That's really interesting. I wonder even logistically how that occurred.
Yeah,
Okay,
like
wow.
I guess I'm like kind of just glancing over this right now. Apparently, like his owners owned him in Missouri. They traveled to Illinois and brought their slave with them. Then while he was in Illinois, he said that because Illinois doesn't allow slavery, therefore as soon as I got there, I'm a free person. And then the Supreme Court basically just said, no, you're not. You still have to go back to Missouri with them. They still own you.
Nowhere in the Constitution does it say that citizens of a state need to be citizens of the United States. That I don't know what the basis in constitutional philosophy is. That's the kind of jurisdictional holding. Which, by the way, people point to Dred Scott. People point to Dred Scott and be like, isn't that an example of how you would want to overturn a case in the context of stare decisis? Dred Scott was overturned by civil war. Dred Scott was overturned by the 13th Amendment. And guess what? Dred Scott's
14th.
13th. Or 13th and 14th, I guess. Yeah.
14th. Well, no, it was mostly
multiple
14th,
holdings.
they already abolished slavery before.
There's multiple holdings. There's multiple holdings of Dred Scott. And in that particular case, the key holding, the jurisdictional holding, is still good law. In order to be, for diversity purposes for federal jurisdiction, in order to be a citizen of a state, you need to be a citizen of the United States. And so in that sense, Dred Scott wasn't overturned by court decision. And what's more, we're not even talking about stare decisis. You can give colorable arguments for why Dred Scott was wrongly decided without accepting this originalist frame of mind. And so I don't know what it has to do with the problem of viewing the 14th Amendment solely in the lens of the particular circumstances that existed at the time that that particular principle was enacted by Congress or the people.
Right. So the reason I think Dred Scott was a fucked up case is because of the originalist kind of lens here. I think that when you have a court decide that wrongly, decide that, well, look at the behavior of the United States, look at the policies of the United States, look at how the values of the citizens and how we have treated Black people. I mean, obviously there was no intent for them to be people. That was the central logic underpinning the idea, right?
It's more than
Despite
that.
the
I mean,
fact
you're doing a disservice to
that. Well, that was the central argument about why Black people couldn't be
no,
citizens, right? That was the aim of it.
Ever intended to be part of, that they were separate races, and it
Right.
wasn't like over time.
Right, but the reason why that historical analysis is bad is because, well, first reason, it's not found in anything, and then B, there were freed Black men who were citizens and who owned slaves before the Civil War. So they just ignored that. They ignored that historical analysis.
Well, you're ignoring that,
Roe
that you're ignoring that in right after the founding of the Constitution, there also existed. There was no prohibition on pre-quickening abortions in almost every state under the common law.
We can talk about
that. You can do this historical.
Under the common law.
You can do this historical analysis as much as you want. You're always going to find cases, and also people like me aren't against looking to history. And history is extremely important. What the practices at the time are very informative to what matters. Guess what? Because a lot of these constitutional provisions do not explain themselves. What does it mean to abridge the freedom of speech? Right? Who the hell knows?
What does undue burden mean? Right? I haven't heard that yet.
What does that mean? To put a substantial obstacle as a purpose or effect of putting a substantial obstacle in between a woman and an abortion. I mean, what
counts as substantial?
We can keep playing this game. Like that's what the court is in the business of doing, is deciding what is substantial, what's not substantial. Just like the court will oftentimes be in the game deciding what's reasonable and not reasonable. Let's not get far afield. We're still at a very high level of generality of constitutional analysis, which is, so far you've told me you don't think the Equal Protection Clause prevents segregation. Because at the particular time and moment the 14th Amendment was passed, they didn't think that they were getting rid of segregation. That's correct.
They
right?
didn't intend for it to apply. Now, am I personally morally against
it?
Yeah, I know
you're against
it. But then I think that part of that is us as the people not doing our fucking job and passing legislation to actually get this shit codified, instead just relying on weak cases, right? I mean, for years now, Democratic politicians have been arguing to codify Roe v. Wade. They're saying this needs to be national legislation because Roe is a weak case. And every time they came into power, every time they had the political capital to do so, they didn't do shit.
Right? You don't even think it's constitutional. Do you think it's constitutional? You mentioned Wicker at the start of your conversation. Do you think it would be constitutional for Congress to pass a law that puts into being a universal right to abortion in this country? You would think it's unconstitutional, wouldn't you? So don't play this game like you actually,
I don't know.
You were deriding Wickard and the Commerce Clause at your opening. You would be on the first.
Do you agree with?
You would be in the litigation. It doesn't matter whether I agree with Wickard or not.
It matters. I want to know. Do you agree with Wickard?
Yeah, I do agree with Wickard. I do agree with Wickard. But that's neither here nor there. The point is, you don't pretend that you care about democracy, because the moment that this would come into the Supreme Court, that Congress passed
democracy.
The moment that Congress passed a universal right to abortion, people like you would be on the steps of the Supreme Court arguing that it was an unconstitutional usage, an ultra virus act by Congress, and that they have no authority to do so.
Okay, hold on. So I'll have to actually consider it, because I wouldn't say it would be anti-democratic if Congress passes legislation to do something.
I think because it seems like he's just saying, well, most pro-life people would have that reaction, therefore you would.
Yeah, I don't know if I agree with sort of lumping lactoid in with that, but I think there is a good argument here insofar as the you can't just use Congress as a way to capture all these results you want, and then to maintain this idea of the correct constitutional way to go about this, because that still doesn't trump the central question as to whether or not this is constitutional. Seems like it seems like if Lactoid wants to say the way that we get to these good outcomes while still being constitutionally consistent is by going through Congress, that doesn't seem correct to me. It almost seems like he would need to say we can tell based off the actions of the framers and stuff that they obviously intended for racial segregation or something like this to a certain degree. Thus, the answer would have to be to alter the Constitution. So, like, if we want to like enumerate like the idea that like black people are people, we would need to have a constitutional convention about that.
Yeah.
Almost seems like what he'd have to like bite the bullet on, which is like, man, that's like that's a big ask because like it's really hard to go through like that kind of like I guess the question that I think maybe I don't know if Pisco is going to go this far because I think he has much more substantive legal arguments without it's wrong. But like from my perspective, as someone who doesn't have very good legal arguments, like the thing I would just ask him was like, Lactoid, if we live in a world where the only way to get rid of like chattel slavery is to do so in a way that is not consistent with like the constitutional like principles of how we enact change, should we still do it? Right? Like if the only way, if it was the case that, if it was the case, because I think it is, that it isn't feasible for us to have a constitutional convention on all of these really important issues, should we just not do them? Is it more important to prioritize in that instance, doing things in the right and proper way along your constitutional principles, or should we bend the law in order to like do what's right?
Yeah, so that's even going, I think, like one meta level above the entire conversation, right? Because I think what they're mainly talking about is like whether or not something like Roe versus Wade even fits into their constitutional framework. And then the question you're asking is like, but does that even matter? Like, even if it
Mm-hmm.
were bad constitutional law, like perhaps we should still just do things anyway that don't fit into the Constitution.
Yeah.
That would be very democratic,
No,
right?
I think that
So
you would be against it. I think that you would be against it.
hold on. But let's keep in mind, you're calling me undemocratic while you are advocating for a unelected body of judges to determine that states cannot make a law about this. That's what you're advocating.
I really want people to stop saying the Supreme Court is unelected. They're chosen by our elected officials. Okay, guys, this is oh my gosh, come on, Lactoid, you're a right-leaning person. You shouldn't be making these dumb mistakes that are more common to the left now. Gosh, it's just.
I mean, technically, like at that point, I mean, almost everyone in our government is unelected, right? Like everyone who's not like
I can't believe our election is decided by these unelected poll officials that have showed up to be volunteers. Unbelievable.
right, and it's like everyone who's not literally part of the Senate or House of Representatives is unelected, right? Because even the president is decided by the Electoral College,
Yeah,
and then all the
I
cabinet members.
really want people to stop saying this because it's really dumb. It's really dumb.
No, and also
Kidding
like
for.
like
And
would
at the
you
same
rather that the Supreme Court be elected? Because I kind of doubt it.
Yeah, it's just, oh my gosh. I know that Lactoid doesn't really like fall into like the pitfalls of why this argument's really bad. Like I'm sure because when left-leaning people make this argument, they're like, oh, it doesn't represent the will of the people and stuff like that. I'm sure Lactoid wouldn't say that, but just stop saying the Supreme Court is unelected. It is a very foolish thing to say, I think.
Saying that I'm against democracy.
I understand
Explain
that the whole point of individual rights is to take away, is to constrain the people. It's to constrain democracy.
Yes.
And so,
for sure.
Appealing to democracy, I think for you is wrong for two reasons. One, it's question begging.
I didn't start by appealing to democracy. You started by saying I hate democracy.
Didn't you say? Then I must have missed the course of the conversation. I'm not going to be able to recall right now what brought me to mention the fact that you were like, for years, Democrats have wanted to pass legislation to codify Roe v. Wade, as though that would be the proper way to do things. That was your implication, right?
So that would, I think, clearly that'd be better than Roe, right?
Okay.
Whether
That's
or not.
sufficient.
So the implication you were making very obviously was that the right way to do this is to submit it to the people. Am I wrong?
Sure.
Okay.
Yeah. Well, but yeah. The right way to do it would be through legislation.
Okay.
And especially not rely on a case that's as weak as Roe.
Okay, so
we can go into why I think Roe is weak, like the three trimester framework.
Really like a strange argument to make
Yeah.
because I mean that is how they were doing it before Roe versus Wade. The states were making legislation, and that. I mean, maybe he's just saying that we should have continued doing it that way. And
it also just seems like hugely untenable with like the worldview that Lactoid has set out here. Like if the people by popular demand did something that was blatantly unconstitutional by law, should the court not strike that down?
Yeah, and I don't even think that would be his thing. I mean, I think Well, no, in fact, I'm like very certain that it's not, because he said earlier, he says the court basically is there to do two things, and like one of those is overrule earlier Supreme Court cases, and the other one is interpret the Constitution. But when he says interpret the Constitution, like I take that to mean that they must be able to decide on the legal, the constitutionality of laws. So I don't think he means to say that they should just have no role in this. Um,
Yeah, I hope Pisco has some questions here to explore it, because I think Lactoid is sort of moving down a line that Pisco set up some attacks to earlier, talking about how you can't capture all these good decisions by just going through the by just going through the legislative, because the legislative could still be in violation of the Constitution, such that then that law would be overturned. So then that's not a feasible pathway.
Yeah, I mean, I think it it maybe the road he's going down is to say that like the Constitution neither protects a right to abortion nor forbids it, and therefore the court was wrong to say that it does either of those things, and that's why Roe versus Wade is wrong. Like maybe that's the logic he's going down with it.
Yeah, I don't know. This does not seem. This seems like a really weird position for Lactoid to take within his worldview.
Mm-hmm.
We will get to the substance of Roe, but just to be clear, one reason why you shouldn't appeal to democracy in that sense is because the first question is deciding whether or not it's a fundamental right. The whole point of fundamental rights is to be free from democratic impulse, and so in that sense, it's question begging. We first have to determine whether it's right, regardless of like put it to the states.
Point.
And the second reason I think is hypocrisy.
Yeah, I don't know if it's the whole point, but I still see what he's getting at. Obviously, if the people passed a law that was like, gingers don't get any of the rights in the Bill of Rights, that would, it's not like the Supreme Court wouldn't then be like, okay, well, the people have spoken.
Yeah, for sure that is part of the function of having rights built into our legal framework is so that they can't just be like, the whole tyranny of the majority thing. But like recognizing that we do not live in a direct democracy, I think those same rights also function to protect from other government actions that even regardless of whether democratic or not.
Yeah.
Because I think you would be against federal legislation, not just for policy reasons. I think you would think it's unconstitutional for Congress to get into this game.
Instead of you speculating on what I may think on something that I'm undecided on yet.
Oh, okay, you're.
Instead of you speculating on what I will or won't say about something that I'm undecided on yet, I would like to talk about Roe.
Well, no, I want to square away. I want to square away what your thoughts are on fundamental rights, implied fundamental rights, before we get into Roe v. Wade. And so I'm going to start asking you the questions that everyone's going to ask you, which is vaccine mandate. State passed a vaccine mandate, constitutional. No rights problem there.
Likely.
Yeah. Okay.
I mean, so they did, and the only reason is because my understanding is there was a case before where they did it, and the Supreme Court decided.
Well, that's not an answer. There's a case before where it did it in Roe v. Wade.
Hold on. This was very close to the founding of the country, and in fact, I think if I'm not mistaken, it was
Jacobson.
Yeah,
Jacobson's in the 1900s.
No, there was something about small.
There was a case, I believe, where George Washington had the Constitutional Army forcibly vaccinated. I believe is what Lactoid is referring to. Yeah. The other thing I just want to pause. I think this is a really good example. I think where Pisco can start to really poke holes and I think just how ridiculous on the face of it is to be like to interpret the intent based off of necessarily what they were doing, because you get in these scenarios where Lactoid's like sort of saying, yeah, I get, I do agree. Why? Well, there was a case really close to the founding. It's like that just does not, I don't think, come off as very convincing or good to people when you're sort of shrugging and being like, well, there was a particular decision, because it almost implies that like the nature of this right is upon like how many thought exercises we know they went through. We're like, oh well, it's like if we uncovered a trove of letters between like the founding fathers where they were debating a thought exercise on incest does that now retroactively mean that like incest that incest is absolutely not supported because we know they were thinking about it at the time, and still decided not to? You get into like these really weird like catch-22s where like depending upon like what we can prove the founding fathers were aware of and were thinking about, that defines their intent, and it doesn't allow us to and it really limits us on extrapolating what they think, because if we don't have something that we can, unless we have a specific instance, of them thinking about how a principle applies to a thing, we can only extrapolate from that specific instance. We can't extrapolate from the principle itself. We can't say, oh, the founding fathers believed in freedom. What did freedom mean? We can say, well, the founding fathers believed that freedom applied to this thing that they did. Can when they made this decision, can we extrapolate from that decision? We can't extrapolate from the idea. We can only do it from what they actually were applying at the time, which is really limiting, I think.
Yeah, but I think that is actually what he's saying. I think he is intending it to be
Oh
a
yeah,
little
yeah,
bit limiting.
absolutely, yeah, absolutely.
So like on the worldview that he's been maybe I shouldn't say worldview, but you know what I mean, like on his view of constitutional
Position.
law that he's been expressing, like he has said earlier that the 14th Amendment, when it was written, they probably didn't specifically intend it to apply to abortion, and therefore it shouldn't be interpreted that way later. So then it does make sense, if he's being consistent with that, to then later say that when the rights that are relevant to vaccinations were originally being put into the Constitution, they were put there by people who apparently thought that they did apply because those same people did it.
Yeah, it's a really interesting view on legal theory, and it's one that I've never considered before. So I do got to give credit for Lactoid for at least bringing that up. It's man, I'm really hoping that Pisco really dives into this, because this feels like a very important discussion to have on like the divergence of like the legal theory, and it's super interesting as well.
Mm-hmm.
There was one about
Well,
smallpox.
George
too.
Washington had a policy of inoculation,
Yeah.
but
Yeah.
no one denies.
Yeah.
I'm not talking about the military. I'm saying a vaccine mandate, and the punishment for not getting a vaccine mandate, Lactoid, is death. Constitutional?
I think that'd be cruel and unusual. So no, not constitutional. 8th Amendment
Okay, so
or 5th. I don't know.
you go to jail for a year.
I would still think that'd be cruel and unusual. I mean, you could probably attach some kind of fine to it. Excessive fines have been repeatedly, determined by the courts to be excessive and cruel and unusual. I'm not denying cruel and unusual, because that's spelled out in one of the
But
bills.
it's not,
like that's literally spelled
well,
out.
it's whatever it means to you, right? And I'm assuming that you agree with Justice Scalia.
It's better than a penumbra.
I'm assuming you agree with Justice Scalia that that the death penalty as applied to 13-year-olds is constitutional. That's not cruel and unusual.
I mean, was that probably?
Yeah, I mean that's what Scalia thought. That's where her historical analysis brought him, that it wasn't cruel and unusual to put 13-year-olds and 14-year-olds to death. And so I don't know why you get to now, in the very liberal society, determine that 1 year in jail is cruel and unusual with respect to vaccine mandate.
For a vaccine mandate, I'm assuming that Scalia is not saying that the 13-year-old should be killed for refusing a vaccine. I'm guessing what the death penalty is applying there is for murder.
Do you think
am I wrong with that?
Well, why would it be
Hold on,
a felony?
Stop.
Felony.
No,
a felony.
No, murder.
A felony.
Name.
Well, no, Justice Scalia is against the other cases too, where he says that the death penalty can only be for murder. He was in dissent in those cases as well. Take something. I mean, I don't even. It's crazy to me. Do you think it's
okay?
Do you think it's unconstitutional?
Serious
Do you think it's unconstitutional to put someone to death for embezzlement, or to put someone to death for fraud?
Yeah, I think so.
Why?
I think that's pretty clear based on like all the rulings and interpretations of the clearly spelled out cruel and unusual.
It's not clear to Scalia. Scalia disagrees with you. I mean, there you have two originalists disagreeing on.
Sure.
Okay. So
well, hold on. So I'm not saying I'm like disagreeing with Scalia in all of his interpretations. I already said that yeah, likely there's not a constitutional bar on certain punishments for people who commit horrific crimes, right? Now,
You could decide
I,
what's
I do
terrific.
think
and-
I do think it was a little bit Weasley to try to like mix the 1 year with the vaccine. That's ridiculous, but death penalty for 13. We're not talking about refusing a vaccine. We're talking about a heinous felony in that situation, like murder or like maybe raping 8 kids or
wouldn't
something.
it wouldn't be
I don't know. That's like
unconstitutional.
an interesting that's an interesting like legal question about whether or not like that's cruel and unusual. I think when like the punishment fits the crime in that scenario, it's probably not cruel.
Okay,
and
but the
unusual.
vaccine mandate is not unconstitutional if it's like a tax. You said, right?
I said maybe some kind of fine,
All right.
and maybe you could attach some kind of punishment.
Here's
I don't know.
the kicker.
Further punishment.
Here's the quicker, and then we can get on to the actual lines of cases, which is
or Roe, where now we're in.
Is suppose the government says to a woman who's pregnant, or says that we reserve the right to force any woman we deem to have an abortion. We get to decide for you whether or not you're going to have an abortion.
This is a really interesting argument. I'm
Is that
curious to see where this is going to go.
I do not think that'd be constitutional. I think at the time because at the drafting of the 14th Amendment, they were doing the exact opposite. So obviously their intent wasn't to have that happen.
Wait, so because there was a policy determination and there was laws enacted that were contrary at the time, that now we have to follow all the laws that existed at the time?
I think it obviously contradicts like the intention of the 14th Amendment at the draft.
Why?
I think it obviously contradicts the enactment of it.
Why?
Right?
Why would a law that forces certain women to get abortions, why would that be unconstitutional?
I've already explained it.
Because at the time there were laws against abortion. All right, we changed the laws.
Combined with the 14th Amendment. Yeah. Well, now you could obviously change the 14th Amendment. You could change the Constitution to say the government's now allowed.
But the Constitution doesn't say.
And then hold on. And then legally, right? If you did change the Constitution to say the government can force someone to get abortions, then yeah, legally you could.
The Constitution does not say that you get to be free from the government telling you when to get an abortion. It doesn't say that. Where does it imply it? You're the one who's saying that they didn't.
Hold on. At the very beginning of this, I didn't completely discount the idea of like unenumerated rights. You seem to assume that I do.
Okay, that's what I wanted to get it clear.
I think there's a little bit of a miscommunication here that Lactoid's having. Pisco is not saying that he doesn't believe in enumerated rights, period, but that if we cannot find a constitutional right enumerated to protect the right to have an abortion, then it doesn't seem that there would be a constitutional reason why you couldn't have like the state carry out an abortion.
Yeah, exactly. I took it as like kind of a reversal of Lactoid's position, where he's like,
it's a really good argument.
Like if you think the state should have the right to decide whether we get abortions, then why couldn't it just take that same right to decide and just decide in the opposite direction?
Yeah, and I don't think Lactoid's answer that we didn't have laws at the time doing it is sufficient, because within his worldview, that works insofar as the question of Roe v. Wade previously within his worldview. Because within his worldview, you can say, clearly the 14th Amendment doesn't protect abortion rights because abortion rights were being violated and the court didn't. Thus, we can tell that their intent was not for the 14th Amendment to apply. But in this case, I don't think you can say that constitutionally they clearly did not want the state to be carrying out abortions, because it's funny, this is exactly the problem I think that we just laid out earlier, is we don't know, because there weren't any debates at the time. Should we have a policy of forcing certain women to get abortions? There was no policy at.
When was the eugenics movement? It was like really like late 1800s, early 1900s? Is that
right?
Yeah,
I believe so, yeah.
Because I know at one point there was a thing of the state forcing people to get abortions. Like that.
Yeah. That's actually interesting. You could really, I wonder how that would sort of mutate the argument if you went to that period in history and looked at like Margaret Sanger, I think her name is, and stuff like that. But yeah, no, I think Pisco's right on the money here. We can't tell what their intent was constitutionally as to whether or not, we should be able to, because it wasn't a question of the time. So it seems like it would be pretty open. But obviously, on the face of it, I don't think anybody, including Lactoid, would want to be like, yeah, it would be constitutional for the government to have, these horrendous laws like the death penalty for vaccine mandates or things like this.
Yeah. Let me try to look up the timeline of this stuff, because like depending on when all this stuff was happening, um, I don't know. It's really interesting because if you can make an argument that vaccine mandates are constitutional because they happened soon after the founding of the country, then it seems like you could perhaps do the same thing where if you say, well, the eugenics movement happened soon after the 14th Amendment, I don't know.
Yeah.
Um, you know what? I'll just look this up and we can continue with the video while I'm looking at it.
Answer from you on, which is
I have been very clear. My whole
you've been
effective
sketchy
summary
on
spent- we probably we no, I'm not even sketchy. We probably spent 15 minutes when me saying like, yeah, there's like a new scenario or like there's like an interesting like modification of rules. Like, yeah, maybe we could apply it there. But in a situation in which during the drafting of the 14th Amendment, you had like a massive pro-life push across the country that the 14th Amendment was not applied to. That is a incredibly different historical scenario, and to interpret it as anything else, I would argue is dishonest.
so you have an individual right to be free from government intrusion in your decision not to have an abortion, but you're not have an individual right from the government to intrude on your decision to have an abortion. And that's backed up in historical analysis. Somehow, you think that the Constitution says that you have an individual right to protect the government against having or forcing you to having an abortion, but not into not having an abortion. Square that in your head.
Do you think these two, just because they both contain the word abortion, are the same thing?
Well,
like,
how can you, on the one hand, be wring your hands and pearl clutching about the fact that this is so untethered for this is judicial lawmaking, it's not anywhere in the Constitution, but you're essentially finding an individual fundamental right to be free from government intrusion in your decision to not have an abortion, just not your decision to have an abortion, and then to pretend that this is like reasoned constitutional interpretation is wild.
Wouldn't the Fourth Amendment apply to that though? Right?
I believe so. Yeah, no, but I'm consistent. You're not.
Right. Okay. So no, hold on. For Fourth Amendment, seizure of the fetus. Explain how that. Hold on. How does the Fourth Amendment apply to a pro-life policy? Explain that one.
So you think, well, as applies to women?
Hold on.
As applies to women or applies to baby?
As applies to women, right? So we're talking about the Fourth Amendment here, okay? So you're saying what is the constitutional basis that would prevent the government from forcing someone to get an abortion? I'm saying, like, potentially here, search and seizure, right? You don't have the right to seize and search somebody, right? Now, does that mean?
Okay, I'll use that to abortion. I'll use that for abortion. Search and seizure. It's a seizure to force a woman to have an abortion, or to not have an abortion. It's a seizure.
How is yours a seizure? Because you're literally like you are seizing the fetus from the woman, and on the other hand, you're just like telling a doctor you cannot do this procedure. How is that a seizure?
So, I really don't understand. First of all, the fourth.
Wait, no. How explain to me how telling a doctor it is illegal for you to like do this procedure. How is that a seizure? Explain that.
You're in the same sense of you. I don't know, forcing a woman to do anything or forcing anybody to do anything. Could be considered a seizure.
Hold on. So we can't.
You're directing someone.
So you're saying we can't ban medical procedures anymore?
You can. Yeah, you absolutely can.
Sure, you
can. But you're having this theory that somehow you can. The Fourth Amendment is meant to apply to police actions, by and large. Is meant to apply to police investigations.
The power of the state.
And it's not meant to be put, and it also, the Fourth Amendment says unreasonable searches and seizures. Assume that you have a warrant. Assume that a judge signs off on all this stuff. You're not going to be able to use the Fourth Amendment to save you from all the bad hypos that you have to bite. And you pretending in the 12th hour in the fourth round, or I don't know, the fourth quarter, that I'm going to cling to something. I'm going to cling to the Fourth Amendment. I think it's preposterous. If
you just brought up this hypothetical, I didn't hear it beforehand. Like
it's in Casey.
Thinking it over.
This hypo's in Casey.
I'm sure
I stole
didn't
it.
Review that specific part. I didn't review that specific part of Casey then before.
Okay, so I got the Fourth Amendment here, so I'm going to go ahead and read that. This one's pretty short. It says, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. So it's basically like, this is like why we need search warrants and that kind of thing. And if I'm understanding correctly, it sounds like Lactoid is trying to use this as a reason why you couldn't be forced to get an abortion.
Yeah, I think Pisco's asking these hypotheticals, if the court does not take a opinion on like the nature. Let me see if I can repeat this in such a way that I think Pisco would agree. Pico is saying that, if it is the case, Lactoid, that you think that the court cannot interpret abortion as having been something that previously, or as having been something that's been protected, and you instead think these decisions should go through the legislature, then wouldn't you say that it would be unconstitutional still for them to make a decision on like, oh, forcing people to get an abortion? And Lactoid saying no, well, because that violates the Fourth Amendment on like searches and seizures, which seems pretty ridiculous. I think Pisco spelled this out earlier. You can't just use you can't get out of all the bad hypotheticals you'll have to bite the bullet on if your standard is that, oh, we should be doing things through the legislature by the intent which we interpret off of the actions taken of the court back in the day.
Yeah, I think there's no chance that when they wrote the Fourth Amendment that they intended this to prevent forced abortions.
Yeah, actually, yeah, you would just go right there.
Yeah. And so, by the way, like, I looked up the history of the eugenics movement, and apparently it started in the 1880s. So this would be like 15 to 20 years after the 14th Amendment, for whatever that's worth.
Yeah.
It's the majority opinion.
Because it's a majority opinion. Like that's like deliberating whether or not the state can force a woman to have an abortion.
Yeah.
Okay, I'll go back and reread
I believe
it.
it's in section 3 of the opinion.
You're good.
I stole it.
Con law class, fresh in your memory.
Con law was like 3 years ago. What are you talking about?
You didn't take con law too?
1L.
You took them both 1L.
There's only one con law in my school.
Oh,
yeah.
Shit.
The point of these examples are meant to illustrate is, of course, everyone understands there is implied rights. I would agree that bodily autonomy and privacy give you private rights with respect to keeping the government out of your decision whether or not to have an abortion or forcing you to have an abortion. And likewise, I think there's a privacy interest at stake in vaccine cases. Not necessarily that you're going to win on the vaccine cases. I don't think you're going to win on the vaccine cases. But
why not?
Because I think no right is absolute, and you would grant that as well. I'm assuming you do not deny like the tiers of scrutiny analysis or the fact that you can have ways to bypass individual rights. And so I think that everyone wants to accept that there are individual implied rights. Even you do, because you're acknowledging, whether you find in the Privileges or Immunities Clause or in the Due Process Clause of the 14th Amendment, or both of them somehow, you are acknowledging that there's implied fundamental rights through the incorporation doctrine and this like new circumstances, whatever you're talking about now, which has no basis in history. Ironically enough, it has a basis
because it hasn't happened.
Well, but that's more of a reason to think that there's not an implied right by your own analysis.
It's never happened, and it wasn't happening at the time the 14th Amendment was written.
Why would the 14th
or
Amendment,
any in history?
If you're an originalist and if you're tied to the history, why would it make sense to say that implied rights are the ones that aren't deeply rooted in history? They're the ones that were, the 14th Amendment is meant to provide implied rights as respects phenomenon that we never dealt with. That seems to be exactly what Scalia and other originalists are fearing that judicial actors are going to do, is to imply rights for new situations. And so I have no idea why you would ever grant that would be an okay exercise for a judge to determine for themselves what
Scalia has done it plenty of times, right? Scalia even said, right, Fourth Amendment protects you from police scanners scanning the heat signatures of your house, right? That was a major case. That was Scalia.
Yeah, but
again, like changes in technology and changes in circumstances, as long as we're looking at the basis of the right.
I'm so glad
it can apply. But when you have a 14th Amendment which is being drafted at the exact time and which is a massive pro-life shift and it doesn't affect it whatsoever, right? Fuck, like. It makes no sense.
I'm so glad that
any kind of historical analysis will obviously show it can't make any sense. Now you've been asking.
The idea of like, well, Scalia said that we can interpret the Fourth Amendment to prevent body scans and like so somehow that is consistent with originalism, but then like we're gonna go originalist on the 14th Amendment because there was a shift toward pro-life happening at the same time. Like that just seems like really a stretch.
Yeah, I think I it, I think the argument is fundamentally sound, but I think this is a really bad application. Like, I think it's fair for like Lactoid to say, clearly, I think it's fair for a Lactoid or like an originalist to say something along the lines of, um, the founders believed in this principle as seen in the decision they made about like muskets, and the rifles that we have today are analogous to muskets in how we treat them. I would personally disagree with that, obviously, but so thusly, it's fair for us to then bring that originalist forward. So, like in the same way that the police using heat scanners to scan your house is no different than like a police like officer like looking through your like window. And so, how they treated police officers going up to your house and looking through your window is how we should treat these heat scanners. But then it feels really weird to then try and apply that standard on abortion, not just to the banning or not banning of abortion on or on a constitutional level, but then the application of federal law using abortion, right? These hypotheticals that Piso keeps going through, because there isn't any like constitutional opinion. Like, is there historical precedent for us to do research and be like, oh, this was the opinion of the founders as to the constitutionality of leveraging abortion as a punishment? I mean, no, right? I don't think anyone was having these debates, right?
Right. And it just seemed like that's what Lactoid was saying earlier. It was like, well, it looks like when they wrote the 14th Amendment, they probably didn't even have abortion on their mind as it applies to this. That it just seemed like they just didn't intend it to be pertaining to that. But then now he's saying like, oh, but there was a big shift toward pro-life at the time, which kind of suggests almost like, well, that maybe they were pro-life when they wrote it, as opposed to they just didn't
Hmm.
even have it on their mind. It just seems like, I don't know, a
Hmm.
confused argument.
Yeah, and I thought Lactoid earlier had made the argument that they did have it on their mind because there were laws in the books at the time. That was, in fact, I'm almost certain that was pretty central to his argument because he's making the case that there was an affirmative position being made, that they were affirmatively stating a position on whether or not abortion was or wasn't constitutional, in regards to bans on it would be, because that's such a question in Roe. That's the other, because the really tricky thing for Lactoid here is that the constitutional position was not one stating whether or not abortion should or shouldn't be allowed, but whether or not bans on abortion should or shouldn't be allowed. So
Right.
he can't use that to then escape all these other applications of abortion that are outside of the context of just outright banning them.
Right, right, right.
I mean, a lot of
Yeah,
questions,
go ahead.
which is fair. I want to ask you a
Sure.
question. Okay. Why do I have a privacy interest in abortion, but I don't have a privacy interest in any kind of surgical procedure between me and my
I
body?
don't think that it's best thought of as a privacy right. I think it's one aspect of it, and it's one that the Roe court focused on. But the lines of cases that it was deciding upon, Griswold and others, cases that you reject. And keep in mind here, just a parenthetical note for everyone who's watching.
Contraception,
He-
Griswold's contraception.
Everyone who thinks that these people aren't these people, I put you in that bucket, Lactoid.
These people.
people.
Wow, that's racist.
The people who are shilling Alito's opinion, and Lactoid's even more extreme than Alito. Lactoid is saying that Alito's wrong about Griswold. Alito's wrong about all that stuff.
Yeah. Yeah, Griswold's trash. I thought that for a long time.
So in other words, it would be constitutional for the government to say you're not allowed to buy condoms. It's a crime to buy condoms. That would be constitutional. So says Lactoid.
Yeah. Yeah, absolutely. What's the difference between progesterone and fentanyl? Explain that one, right? Why is it constitutionally protected for me to like have a pill of progesterone?
I'll tell you.
But if I buy a pill of like fentanyl, or if I buy like a joint, but the whole drug war is predicated on the fact that like Griswold shouldn't exist.
No,
but yet it does.
No, because you're thinking as I think
as
incorrectly.
No, hold on. I'm thinking as the logic explained in the cases.
Because you're thinking of the right as a certain set of circumstances as opposed to a value. Just like you mentioned the Kylo case, I believe, the thermal imaging case where Scalia very beautifully applies the value of the Fourth Amendment to the constitutionally enumerated areas to today. What we're doing he is.
No, he's applying a consistency among different methods, right? When we're talking about Griswold, a consistency, right? Consistency is kind of important, right? When we're talking about Griswold, right, we're talking about the right to privacy because we don't want the cops coming in and like searching your fucking house for birth control. That was the appeal made in that case. Now, fast forward, we have the DEA busting down doors to search your bedroom for like marijuana or fentanyl or, you know, cocaine. And if that is constitutional, if any kind of anti-drug law is constitutional, how the fuck is
I don't think that Griswold is properly
decided?
understood as you get to do whatever you want in your house. That's not what Griswold's
No,
holding this.
no, I agree with you. That's not what it says, but it's talking about a type of a specific substance, a drug, right? Progesterone or estradiol, or you know, the different types of things that go into birth control, right? So that as a drug is like, that's privacy, okay? Whether or not you're taking progesterone, you got a privacy interest in that, but you don't have a privacy interest in other substances such as marijuana.
So the fundamental aspect of liberty that these cases represent, in my opinion, is not thought of as you can do whatever you want in your house, or you can take whatever pills you want in your house kind of case, or you can have sex with whatever you want in your house. You know, I don't think that bestiality is an individual right. I don't think that, like, I don't know, child molestation is an individual right, or any of that stuff. The key holding in
hold on, I don't either, right?
Okay.
Let's just
no, but there are people, if you buy the reasoning that like you can, Griswold is about doing things sexually or related to pills in your own home or in the private marital bedroom. First of all, there's Eisenstadt.
You're thinking about a Bergefell. Sorry, that's the one you're thinking.
No, well, we've already read. Do you disagree with Loving versus Virginia? Are you going to say that that was wrongly decided too?
Okay, it likely is not constitutional.
So
government. Do I want it to be? I want it to be legislated. Yeah.
So a constitution. So it is constitutional to ban interracial marriage
under the current flawed constitution. I'm advocating for changing it.
Okay.
Right. You're advocating for keeping it the same.
All right. So to answer your question, because we've gone afield, which is how do you distinguish, and why do I think Roe v. Wade is a privacy right for Roe v. Wade, but there's not a privacy right with something else, with doing drugs or all that stuff.
Or possessing. Why?
Yeah.
Hold on. Griswold specifically, you can possess a pill. The privacy right to possess a pill of progesterone. And
later on,
but it is not.
Later on, it's to distribute. Later on, yeah. Because what Griswold in these cases is about the intimate decision about whether to bear or beget a child. That is what these cases. That's what it says in Eisenstadt. That's the follow-on case.
Griswold never talks about any kind of right with specifically bearing children. Roe v. Wade doesn't talk about it whatsoever. This was the central thrust. Why wouldn't they just say it?
Eisenstadt happens a few years after Griswold, and that quote is in there. I'm not sure if Roe specifically cites Eisenstadt. I actually think they do. I think they cite Eisenstadt, and so it's in line with those cases. Casey explicitly, constantly is referencing Eisenstadt, and that's how they're best understood. And it's totally in line with the substantive due process rights related to raising your children the way you want to being free.
I just want to point out, Griswold v. Connecticut, the case that they were talking about earlier was about the right of married couples to have birth control in their possession.
Yeah.
And then Eisenstadt v. Baird, the other one that they're now referring to, was about the right of unmarried people to have contraception.
Free from sterilization. I assume you think the sterilization cases came out wrongly, or at least I don't know. You think Buck v. Bell was decided correctly?
There's a couple of them that are in contrast with one another.
Well, you think you think it would be constitutional for the government to forcibly sterilize anyone they want?
Anyone they want? That's not what Buck v. Bell held.
Well, no, but I'm not asking you I'm not asking you Buck v. Bell. I'm asking you a separate question.
Yeah, I'll have to read the case again. I mean, I do think that some people.
Why would you have to read the case? I'm asking.
Like again, I'll have to read the case again to see what they're appealing to, right? Because I want to know if they're like what kind of historical analysis there is. I'm not a walking encyclopedia on all of these cases, right? Now, I do think there is examples of where we should like castrate some people, right? So like repeat pedophiles, I think there is an argument to like castrate those people, and that would be sterilization under. Is that constitutional? I would say so.
Okay, so to make sure that that you feel that I've answered your question is I don't see the right as abortion qua abortion. I think the right is properly understood as decisional autonomy right related to your decision to bear or beget a child and to make that intimate decision, not necessarily one related to the specific historical record on any given practice. Because if I accepted that, I'd have to deny Brown v. Board, and I don't think that that's the best way to to do
So
constitutional
let me
analysis.
well, I know, because it's a good talking point. So if we're looking at the what your position here is, I'm curious, right? So what you're saying is that there's a penumbra of privacy when it
No.
comes to the 14th Amendment, right? Hold on. It doesn't specifically say privacy, but that's where privacy is a penumbra. And then there's like abortion, which is also not specifically said, that's within that. And then like that right is protected by like yet another thing which is not mentioned, which is like the right to beget a child. And then all of this is
But you're doing the same.
there's no issue with that.
You're doing the same stuff.
No,
you're
hold on.
implying
So
rights
hold on.
too.
Why do you got to be as crazy as me then? Explain to me why, or do you have any kind of historical basis to justify?
So the ninth.
Hold on. Do you have any kind of historical basis at the time of the drafting of the 14th Amendment to justify that there was any intent whatsoever or any reasonable like extrapolation from anything that anybody was saying that they intended for there to be a right to like begat a child?
Yeah.
In the 14th Amendment.
So
really?
Wow.
Yeah.
That's a
well, I mean,
strangely
you are
framed question.
recognizing one by answering that you think it's unconstitutional.
Because
Yeah.
he threw in the middle of there, like, do you think there's any like reasonable extrapolation to that? But then he was like going back and forth between do you think they intended this versus do you think there's a reasonable extrapolation for the and it seems like I don't know, like Pisco's been the one arguing for reasonable extrapolation the whole time, and Lactoid's been the one arguing for original intent the whole time, and then
Yeah.
it seems like he's mashing them together into one question.
He really needs to dig apart, I think, what Lactoid would view as a reasonable extrapolation versus what Pisco would, or what Pisco would and what Lactoid wouldn't. Right, that where there would be a disagreement. Because Lactoid it seems that Lactoid's position really limits you, where you can only really extrapolate from direct applications. Well, we can't extrapolate based off of what they said. We can only interpret what they truly meant based off their actions. So if there wasn't a case where using abortion as a punishment was like a law that was debated over, then we really don't know.
Yeah, it does sound like that's what he's saying, and I would like for him to spell it out explicitly if that is what he's saying. But I think you're probably right.
I will answer affirmatively, but just to be clear for the audience's sake, Lactoid is also accepting that the Constitution provides a right to bear or beget a child as applied to having the child, with respect to the government not forcing you to get an abortion. So
it was the 14th Amendment, right? Or the 4th Amendment is what I think I appealed to.
Okay.
Again, off the cuff.
All right. So that was pretty good. I think the 9th Amendment embraces tacitly that there is going to be an exercise of finding unenumerated rights. At the very least, that's what it means. If it's not the source of the rights, it's themselves. It's a rule of construction that makes it understood that the rights specifically enumerated in the Bill of Rights and the Constitution are not the only rights that exist. Why put the 9th Amendment in there if it doesn't embrace at least the exercise of trying to find out what those implied rights are? That is a historical textual
try to find out what they are. Like, what do you mean try to find out what they are? Where do you find them?
To discover what individual rights are so deeply rooted in history and tradition, so implicit in our concept of ordered liberty. That's a quote from Cardozo. That's what the exercise is, and it is rooted by history, but it's not rooted in the specific practice of abortion, but in the value of what does our liberty even mean? What does it mean to be an individual if it doesn't include the right to determine whether or not to have a family?
I have a hypo for you. What if at the drafting of the 14th Amendment, they specifically said during the drafting, they were like, we do not intend for this to apply to abortion, because abortion is murder, right? That's, let's say, like they didn't put it in the 14th Amendment, but that's what they said during the actual.
You believe in legislative history now? I'll take Scalia's line that they didn't enact that. They didn't enact the committee report. If I'm being non-facetious, I would say I would take that into consideration when interpreting. It wouldn't be dispositive, as it never is. Legislative history is not dispositive. You would agree with that, right?
So, it can be when we got we have an unenumeration.
It's convenient that legislative history sucks.
It's convenient that there's we're applying things and we're looking at things on a case-by-case basis and not just
dispositive means that it settles the question.
When we're talking about an unenumerated right, and you have so we're already saying that like this is coming out of, it's not even specifically said, right? We're already saying this is like coming out of something based on like our understanding. And then we're going to say like the drafters like specifically intended for this not to be the case. I like when we're talking about an unenumerated right, like I would say legislative history should be dispositive in that case, because I mean, how could you possibly fucking argue that they didn't, that like they intended for that to happen ever?
Okay.
They obviously didn't, right?
Well,
would you agree that they obviously, if they literally were taught, like everybody was in agreement, yeah, not abortion, you would say like, yeah, they didn't intend for it to apply to abortion. Like not
Yeah,
only did
but I
they
already
not intend for it to apply to abortion.
I
But hold on,
granted
hold on. I know you did, right? But now it's they specifically intended for it not to apply to abortion. Yeah.
Yeah.
And now, and so how, like, let's say that happened. Would you still hold your position on, you know, the right to begat a child being found in the 14th Amendment?
I think it would be a lot harder of a case if there's specific evidence that they considered it, and then
a lot harder of a
rejected.
case. You criticized me for doing that.
What?
No, yeah, you're saying it's a lot harder of a case.
I don't know
right?
what legislative history you're pointing to, but the thing that's dispositive.
I'm saying it's hypothetical.
Yeah,
It's an
yeah.
if it exists.
So is it?
Would you?
Is it every single person who voted on it says it? Is it the sponsors of the amendment? Is it a statement
The majority.
made in a speech? Okay, the majority.
Yeah, the majority of them all signed
in a signing statement say, and this is not intended to apply to abortion.
No, they were like, yeah, and we all agree it's not intended to apply for abortion. Like, like everybody put up their hands.
I think
right?
that's pretty.
Like, that was recorded.
I think it's pretty strong evidence that if it's the majority of people who ultimately end up ratifying, or the majority of states, that's pretty strong evidence. But it's not necessarily dispositive if there's other evidence that exists to the contrary. But I would say in that specific circumstance, I think probably my disposition would be that it's not meant to be in the.
Yeah. So okay, then explain to me then how the 14th Amendment, which is talking about something ratified by the states, those very states ratifying it are criminalizing abortion within their borders.
Because
how can you look at that as anything but they don't intend for this to apply to abortion?
That is different than a specific statement. Or wait, do you have a problem with that? Are they not the same?
They're criminalizing the procedure at the same time they're voting on this amendment.
So
obviously they don't apply.
So is segregation. You're talking about a specific, like someone who's essentially a group of people who are saying we will not ratify this without the understanding this is not applying to abortion. But what they did was they signed something that had very general language. And in signing something that has very general,
we're talking about most states. We're talking about the vast majority of states here.
I agree. By the early 19th century, all of them had criminal abortion laws. And no one,
except for like 2 or 4 or something.
I'm pretty sure every state in the union by like the 1900s had criminal abortion laws. No one's denying that. What you given me is like an example where there's in consideration of the specific amendment, the primary actors, whether that's the state, the ratifiers, the people who proposed it, specifically thought about and put to the side this specific thing that you're talking about, or the abortion right. That is not the same as at the same time of passing an amendment, the practice of the states were to do a certain thing. If that were the case, I'd have to accept that Brown v. Board were wrongly decided, but I don't think Brown v. Board was wrongly decided, because I think that these words, these very general, capacious terms, equal protection of the law, due process of law, liberty, you can't be mad that you pass a very general term. Another one is cruel and unusual, and then be surprised with how the courts are going to adjudicate it. They have to adjudicate it, and they have to come to determination about what those terms mean. Yeah. And so
I would say this. I would say, and this is, I guess, to outline my point for the benefit of the audience as well. I think that Pisco said that if we had it in writing that they all agree this wouldn't apply to abortion, then it would be obviously right. Yeah, but if you have a scenario in which the vast majority of states at the time of the 14th Amendment are criminalizing this procedure in their states at the same time they are voting on the 14th Amendment, that's not enough evidence to really determine whether or not they thought the 14th Amendment should apply to abortion.
In the same,
I think it's crystal clear, and I think any kind of honest historical analysis shows that there's no reason why you would be voting on something to be a right, and in the same breath be voting to criminalize it.
Same thing with segregation.
Apparently, there was a movement to criminalize abortion, which started around the same time as the 14th Amendment, and it took about 40, 50 years to culminate, and then by the time they got to 1910, they had all criminalized it.
Yeah. Then that is a lot more I think contentious than what there's a pretty big distinction between that and like the hypothetical that Lactoid is offering.
Yeah, I agree.
I do think there's a really good argument for Lactoid to have, though. I don't think Pisco has had a very good answer for it, which is that obviously maybe I shouldn't have pen, obviously, which is that Lactoid is saying, you do still care about the intent somewhat, right? Because
Yeah.
if it was the case, so then, how do we then distinguish, where does it matter? When it does seem that there probably was, and I mean, I definitely think Lactoid is probably right on the money that, like, it probably was, abortion was probably not very popular when the 14th Amendment was passed. Most people probably did not like it very much. It's particularly the people who were, passing this amendment to the Constitution. So then how do we arbitrate the degree of influence that knowledge about their intent, how do we arbitrate how much influence that holds over our decisions now? And I think that's a really good line of attack for Lactoid to have.
Yeah, I agree.
No, it's different because it's different because in order to ratify that amendment, they needed, a majority, right? It's not like, and it was also a majority of states that were criminalizing abortion. With segregation, you could have had like a minority of states that were like bitching and complaining as they were getting outvoted. That's not the case here. The case here is, if they actually intended for it to apply to abortion, it wouldn't have passed.
So the difference,
or maybe the other way around.
You're not denying that there was widespread segregation in public life across the United States during the passage of the 14th Amendment, are you?
No, for sure there was,
Okay.
but I'm not sure there was anything like equivalent to like the actual state laws of Jim Crow until that whole era. I think it was a lot more de facto as opposed to de jure, especially in the northern states, if I'm not mistaken. It wasn't like the state governments like instituting those sort of things. It was really, we saw a lot of the state governments instituting those rules during the Jim Crow era in the South, and the South was the minority of states.
But you would agree that no one thought, regardless of whether or not there was a particular signing statement or anything in the 14th Amendment, no one thought that the Equal Protection Clause desegregated. No one thought the Equal Protection Clause applied to women. No, right? This is just for racial. And what's more is probably mostly black people, as opposed to
they
other
didn't, but they weren't actively criminalizing it while they were signing it. This wasn't the case. Right?
You're saying differences, but you're not explaining why that's a distinction with a difference. I mean, yeah,
because it's common sense. Like, okay, I agree. I have to rest some assumption here in common sense that people accept that if you are in one breath voting on a specific constitutional amendment and in the next breath saying this practice is illegal, that practice probably doesn't fall under the right in which the unenumerated right in which that's coming out of this 14th Amendment that you also just voted on. I think that's a pretty safe assumption.
I think that history's, first of all, I would think differently about the history of segregation as applied to black people. Thinking also like racial covenants and that kind of stuff. And
right back to race.
You want to?
Well, I think it's a fair example.
It seems like the argument I would probably want to make if I were Pisco here is I would want to say that like maybe they really didn't intend for it to apply to abortion, but maybe maybe those people at the time were violating those unenumerated rights, and they were wrong to do that.
Yeah. I think the question that Pisco should really go after here is, what do you think the argument would be? Not did the passage of the 14th Amendment support a ban on abortion or not, but what would their argument be? How would they justify it? Because I think I think Lactoid's position, and this hasn't really been explored very much. I think it really is not set up to handle people passing constitutional amendments or constitutional amendments being passed by people who are inconsistent or do not have like a ironclad worldview, which I think is basically I don't think there is such a thing as a completely consistent ironclad worldview, and most certainly I don't think most people get even close to like the absolute peak. I think the vast majority of people, myself included, have all these pitfalls of human emotion and subjectivity and stuff like that. So the question is, like, if there is a contradiction, they then by their nature they cannot both be true. So then how do we resolve that? Do we choose which side of do we choose to go down? And I feels like it feels like Lactoid is is supremely unprepared to answer that question.
Uh, he might be. It's hard to say. Like because
Yeah, to be fair, he hasn't been given the opportunity,
right,
so
right. And
we
I'm
can't say.
guessing he probably does have at least some system or heuristic to resolve those conflicts, but he hasn't spelled it out explicitly. And yeah, and what's essentially what they're fighting over here, is that there's one version of originalism as where we should take the 14th Amendment to apply at the time the 14th Amendment was written, and then there's another version that could say we should interpret the 14th Amendment in light of the intent at the time the Constitution was originally written, right? So it's like two different historical time periods that might be conflicting with each other, and it's like, well, okay, which one of these is really going to be originalism, right? Is it the original time that this specific text was written, or is it the original time of the document that it's part of?
Hmm. Yeah, I think I'm still not sure if Lactoid has sufficiently, to my mind, answered this question that Pisco has about the application of, many of these decisions in regards to like desegregation or the rights of like women under equal protections and stuff like that.
No, I'm pretty sure he has not yet adequately answered those things. I don't want to presume that he can't, but I will say
Yeah,
that he hasn't.
yeah, that's a much more fair way of putting it.
So no. So your logic here is saying like if we took that logic, then we would have to have some kind of decision that I don't want. Like that's not an argument. That's like the actual process
argument
here.
for those of you saying like it's just consequences. It's not just consequences. The words of the 14th Amendment are equal protection of the laws. States will not deprive people of the equal protection of the laws. That's what it says. And when we sign that,
are you a textualist now?
Everyone starts with the text nowadays. Everyone starts with the text. Of course.
Well, yeah, and then, yeah. You
why are you
text,
acting like you're the only person who reads things? We all
well,
read
no,
stuff.
because you are discounting the legislative history here, and you're saying, well, the text
That's
just says this.
odd.
Because I can read anything to mean whatever I want.
What's odd is the fact that most originalists will say we discount the legislative history. We discount it. We read the words as they were written, and we don't worry about all this other stuff.
You're actually wrong. No, you're wrong on that. That is like hardcore textualists.
Read Scalia's read his reading law.
Okay, so Scalia is not the only originalist. Maybe
Clarence
I have an opinion
Thomas
that disagrees.
Too.
So
Neil
I don't know
Gorsuch
what specific. I don't know what specific opinions you're referring to. I'm pretty sure there are multiple cases in which these justices are saying good things about like looking at the intent of the framers of the particular law. That seems to be the whole point of originalism. At least that's the way I was taught it. But I don't know. You can make any amendment read like I could read the 14th Amendment to justify bestiality. You could too. Do you agree with that? Really?
No.
You don't think that with liberty, I can't say, well, if I can eat an animal, why can't I fuck it? Explain that one.
Because I don't think that the freedom to have sex with animals is one that's deeply rooted in history and tradition.
But abortion, when they're drafting this,
the decision whether to bear or beget a child is deeply rooted in our history.
Well, this seems like Pisco's conceding a really big point here, right? If he thinks that being deeply rooted in history it is important grounds on which to decide whether a right exists, it seems like he's conceding a lot to just the whole originalist concept.
Yeah, I think I think that Pisco could have greatly benefited from putting all his cards on the table earlier in a much more structured way and being like, because I think this is less of a concession and more that like I think he's always had this position. But it really comes off as a concession. I think it's much better if he lays his cards on the table and be like, listen, I think that these are absolutely important, and that's why it's not abortion, but abortion as it relates to the decision to have a family, which I think is a really strong argument, and good for him to go to. It also dodges a lot of it spikes the link on a lot of the typical problems, I think, with trying to argue the constitutionality of abortion bans. I really wish that they had stopped and gone into this textual thing, because I think that Lactoid is being a little silly when he says that oh well, we can interpret words to mean anything. I mean, certainly there are well, certainly you can get certainly there are a lot of ways you can interpret words, and to get to a lot of different places. But it's not as if, if I took the phrase, oh, I like the color green. There's going to be a spectrum of how we interpret that, and most people are going to be, there's going to be a Venn diagram of a million circles of what every person interprets that about. And as a result, we're going to say that most people, if they hear the phrase "I like green," they're going to think, "Oh, he likes the color green." They're not going to think, "Oh, this is, JFK is still alive and he is communicating to me secretly." Like, and I think Pisco could do a little bit of chiding there to be like, clearly the interpretation of these words, can still be done in such a way to have some grounding, even if we acknowledge that, you can theoretically go to some pretty crazy places.
Yeah, and I don't think that Lactoid is worried that Pisco is going to take these crazy interpretations like that. I think he's more worried that the line of reasoning that Pisco is presenting would give other people
Yeah,
license to do
it's the
that.
framework, yeah, and then if this is the standard, well, I think, and maybe I'm wrong here, but I think Lax would say something. And if we use the standard of just interpreting these words, how we mean them, who's to say in another 100 years we don't wildly interpret them to be something different, and then there's a real change occurring there that shouldn't be.
Yeah, which I think is a thing that could happen, right? But
Yeah.
neither of them can do anything about it. It's not like an originalist framework is going to prevent people from doing that.
The thing the thing that I think I would want to ask Lactorder, I would want to ask him, although I would want to brush up on my history first off, before I go in, because I think Lactorder really knows his stuff. Is I would ask him, do you think it is better for the Constitution to bend or break? Because there's a real argument, from my understanding of history, that the founders explicitly wanted the Constitution to bend rather than break as the times changed, and to be very malleable. Because in their mind, they would rather preserve a degraded Constitution than allow the Constitution than have the Constitution take a stand and just break as the society changed to become untenable with the Constitution as it existed in 1791. And that there's a real there was a real strategy to that. It's almost like Nixon going to China. He'd rather have this country that ostensibly we were very opposed to integrating into the system, because then we can have at least some measure of control. And the same way the founding fathers, they would rather have the Constitution be degraded rather than have the Constitution say no, absolutely, this is how it's going to be. A, B, and C. This is exactly what it is. And then when people don't want it to be that way, it just breaks apart. They'd rather let it be fungible and then let people bend it, so that way there's at least still some of it.
Yeah. So, do you think that that's directly relevant to the abortion thing, though? Because I wouldn't think abortion is like a make or break issue for whether the Constitution survives.
No, but I think it is an argument as to the framework by which we interpret the Constitution. Because I think Lactoid would say something here like, no, the Constitution shouldn't bend. We need to not bend the Constitution. We need to look at exactly what the founders did at the time of these amendments, and then figure out, based off of that, what they meant. And that's exactly what it should be. And then I think flies in the face of what I think the position that I'm describing of some of the founders, which is that they acknowledge that that is an impossibility. That's just a non-starter, because it is just not the case that America 100, 200, 300, 400 years in the future is going to exactly align with what the founders wanted. So it's better that the Constitution bend to that society, so the founders can at least have some influence on what they think that society ought to be, rather than the Constitution is thrown out and now they have nothing.
Yeah, I mean, I'm guessing that you're going to get some kind of conceptually similar answer to almost anybody you ask, which is that up to a point it is better for it to degrade than to break, but some amount of degradation is if it were to go far enough, would actually end up being worse than just letting it break and starting from scratch.
Yeah, maybe.
Deeply rooted in history.
Obviously, as not as it applies to abortion, because the people that were writing this specific amendment were criminalizing abortion at the same time they were writing.
That's your failing. Your failing is you view things myopically and at their most narrow. But that's, of course, not the best way to look at these rights, or the best way to interpret them at all. If you were to do that,
okay, I just disagree, I guess.
If you were to do that, I mean, you're led to the conclusion that
Brown versus Board of Education, right?
Among others, right? So think also about the First Amendment. The First Amendment. What the hell do we make? How do we make sense of the First Amendment in the context of circumstances that didn't appear before the framers? So what are we to make about what the First Amendment says about, I don't know, Section 230 or Twitter as a public platform or any of that stuff in that moment?
I've already addressed this. I think a better question would be, what if at when they were drafting the First Amendment or the First Amendment, they were like, yeah, this probably shouldn't apply to slander. Like, okay,
yeah,
seems pretty fucking clear.
No one is denying that historical practice and what the framers thought informs our decision making. No one denies that. I've never denied that.
And by the way, if they at the same time they were drafting the First Amendment, if they were also like the same people were criminalizing laws, like they're instituting laws criminalizing slander, I would think it'd be ridiculous if like sometime down the road we said, well, the First Amendment obviously protects slander. No, like look at what they were doing at the time of the drafting. Clearly, they don't believe that.
Okay, so I'll give you a couple more hypos then. If there were a criminal law in a majority of states that, I don't know, criminalized publishing a certain like religious material or criminalized, I'm not sure, some political movement or something, you would say the First Amendment doesn't apply to that specific political movement or to that specific religious text where there was a majority of states having ratified that amendment, having criminal laws against those practices. Even though the First Amendment says Congress shall make no law abridging the freedom of speech, the fact that there were laws in those states doing that, you would say is dispositive that the First Amendment doesn't reach those activities.
Likely, yeah. If they're drafting the First Amendment at the same time criminalizing this behavior, I don't see how you can say the First Amendment protects that behavior. I would say it's our responsibility at that point, because again, like I said, the very.
Okay, so I just realized there's like kind of a strange ambiguity about the argument that Lactoid's making here, which is that he's saying that they're outlawing abortion at the same time as they're passing the 14th Amendment, right? But there's kind of two different ways we could look at this, because the movement to outlaw abortion was just starting as the 14th Amendment came around. So you could look at it as that they passed the 14th Amendment, then they did a bunch of abortion bans, and therefore it's consistent with that. But on the other hand, you could look at it as, well, because that movement was just starting, perhaps they were coming from the mentality of the history that came before it and weren't really intending it to to be in line with abortion bans.
Mm-hmm. Yeah, I think I think that there is a lot of attacks you could make against this picture that Lactoid is putting out, that like it was the law of the land that all these states were just absolutely banning abortion. There's probably more contention there.
Which, well,
I think
40 to 50 years later it was.
Yeah, exactly. But at the time, yeah. I think there's a lot of attacks there. I think the other thing you could do, and I think Pisco is trying to get at this with like Brown v. Board and stuff like that, is this question of, if we're going off of, not what we think the words should logically mean. Even if it makes, even if we think that the Constitution says 2 + 2 = 4, if they were passing laws that say 2 + 2 = 5, well, then we ought to treat it that 2 + 2 = 5. I think the better line for attack, rather than like slavery, because Lactoid is right, among the northern states, even very early on, particularly in like New England, right, where where the Protestants were really strong, there was a real movement that like this is wrong, really from day one. There isn't that though for things like equality of the races under the law, or like the idea of like equal protection, or the idea of like interracial marriage. And I think that there is a much better line of attack for Pisco to say, hey, in 1776, 1791, in the early 1800s, it wasn't universal that people thought slavery was okay, but it almost was universal that people thought that like white people and black people should not be treated equal, or are not equal, period. If that's the case, then doesn't it mean that any decisions that are based off of that premise are unconstitutional? That the only way to resolve it is like a constitutional convention, and it's almost like you need a constitutional convention to resolve that, which is already, I think, a pretty big bullet for Lactoid to bite. And then I think, I'm just realizing this now, but you could almost say, all right, guys, constitutional convention, we pass the exact same amendments in the Constitution, period. but we do so within the context that now our laws do acknowledge that black people and white people are equal. So now in the future they can interpret based off of our actions that this is what we mean. Um, I think there's also a really funny twist to that as well.
Yeah, I mean, I feel like I mean, I guess maybe this is one of the things we need to research over the next week is like to what degree is it the case that all of the racial equality stuff actually comes from laws overturning the previous inequality stuff as opposed to Supreme Court decisions overturning a lot of that stuff, because the examples that I'm more familiar with are the Supreme Court ones, like the desegregation and allowing interracial marriage and all that stuff seems to have come from the court. And I wonder if Lactoid would respond differently depending on how those changes have occurred over time. I don't know.
Yeah. Huh.
Well,
This is
like okay, he's taking originalism with respect to the legislators, but does he also take originalism with respect to Supreme Court decisions at the time they were written? I don't know.
yeah. Huh. Because yeah, it's almost like all you have to do to ever to, to, ever do a constitutional convention is you wouldn't even need to make any changes. The mere act of ratifying the Constitution within the context of our society doing things means that clearly we're okay with that. So then that's how it ought to be interpreted. Like if we just had a constitutional convention today and passed all of our and didn't change anything, but simply like re-ratified the Constitution, all the amendments, well then Lactard was saying, well clearly when they re-ratified the Constitution in 2020 in it at a time in which they had like support for abortion or something that like Americans do have universal support for, well clearly we can interpret now the exact same words to mean a different thing. It's actually really weird. Lactoid is doing the thing that he doesn't want. Lactoid's position is almost doing the thing that he warns against. You can interpret these words to mean anything. We are now totally detaching like the meaning or the what the Constitution how it should be applied from the literal meaning of the words, and just based off of what people are doing. So we could not change the words at all and massively change what the Constitution is, which just seems like logically like a 2 + 2 = 5 like does not compute, like crash the desktop moment.
I'm actually confused about what you mean by that, because it seems to me like what Lactoid's doing is just pointing out he doesn't want that to happen, and then he's like criticizing Pisco's view that if we were to disregard originalism, then we just get this chaotic mess of interpreting laws however we like. But you think Lactoid is like sincerely saying that we should just reinterpret laws according to
Well, I
while
think
disregarding originalism, or what?
well, I think it's the case that given Lactoid's position, it seems like he's saying we need to change the Constitution. I think Lactoid is affirmatively saying that hey, we need to change the Constitution rather than using these flawed decisions. But given the standard by which he uses to interpret the Constitution currently, if you apply that, then I don't think you would actually need to change the Constitution. You would simply need to re-ratify it. Because if it's the case that we interpret what the Constitution currently says based off the actions of the society that passed the Constitution in 1791, then similarly, if all we did was pass the Constitution in 2020, we could interpret it based off of what the society did in 2020.
Oh, okay. I see what you're saying. No, but I think he probably would agree with that. But well, okay. I guess here's what I'm guessing he would think of that. I think he would say like, yes, if we did re-ratify the Constitution in 2020, then it would be proper for us to interpret it in light of what the views of the people were who were passing it in 2020. However, that's not actually the world we live in.
Yeah, well, we haven't done that, but I think I think this argument does start to become a lot harder when you're like, okay, because then I think it exposes the flaws that just because the Constitution was passed at a time in which these things doesn't mean the tides of opinion don't change or things like that, or that people can't have differences of opinion within that society even while there's still a large standing precedent. I
Yeah.
think
Well, the simultaneous differences of opinion, I think, is like a huge criticism of originalism because it means that there's actually quite a lot of ambiguity within it. The thing with opinions changing over time, I understand that's a thing that people use often as a criticism of originalism, but that one's like um I I don't mean to say that it
It's
doesn't
not as
work. Like,
it's not as self-contradictory as I think a lot of people say it out to be. Because originals would say, yeah, that's the point. People
yeah,
change their opinions, but we can't do that.
that is where I was going with it.
You need to have a specific distinction as to like why certain changes in opinions are okay.
Right, exactly. Yeah.
Beginning of this, my morality disagrees with what I think the law of America is and what it should be, right? I think it's up to us to fix it instead of relying on bad case law to protect
you've already
us.
said that. Yeah, that's a nice thing to say.
Bestiality.
Like,
bestiality.
That's a nice thing to say that everyone wants more
I've talked to
democracy.
Lactoid a little bit,
this,
and
everyone wants that. Yeah.
He's pro bestiality and pro necrophilia. He and I had a little bonding moment because I'm pro necrophilia too, but not bestiality.
Yeah, it's I do got to give full props to Lactoid here. I think he is being very like good faith and like biting the bullets and clearly laying out his position. He's not at all like playing games or anything.
Yeah.
I always really appreciate that about Lactoid. I feel like Lactoid is like it's really nice to be able to like talk to like a more right leaning or conservative person and be like, oh wow, that's like a good point. Like I actually need to think about that. Let me think about how to attack this versus like some of the times when it's just the most sensational, like Biden stole the election. It's just like, oh my god, here we go again.
Yeah. So what a really good thing about Lactoid is that he's somebody on the other side who is not just repeating the same talking points we've all heard 100 times, right? He's actually like a thoughtful person who puts thinks before he opens his mouth, right? But like let me say though, I don't think at any point in the thing about bestiality and necrophilia, I don't think you could say that those are like deeply rooted in history, like really at all, or that any kind of originalist interpretation.
I think
of law
Lactoid would say that.
those.
Yeah, I think Lactoid would say that they're not constitutional, but they ought be. He would be like advocating for like the convention, where it's like whatever amendment we're on, that amendment, the 29th Amendment, is going to be enshrining the rights of bestiality and necrophilia.
Yeah, and to be clear, when I say I'm pro
different
necrophilia, it doesn't mean that I actually want to like encourage necrophilia. It's more that I think it's basically a victimless crime. I think dead bodies are objects that have a lot of sentimental value, and that if the dead person and their family are okay with it, then there's no additional legal reason to forbid it. Basically.
Yeah. Although yeah, I feel like once again like. Sorry to just go back to this, but I feel like, if we wait 20 years, if in the next 20 years there is this wave of, Destiny debates did it, incest, necrophilia, bestiality, America has woken up to the hypocrisy, and there's a sweeping movement of laws that legalize these things, then after that 20 years, within Lactoid's, framework, all we would have to do to amend the Constitution in order to enshrine those things is pass the exact same text. Because now we're doing so in the same so
so
that's so interesting.
So but like any laws that we pass during that time period, whatever they are, would have to be interpreted
it almost means that like laws are now it almost means that anytime you pass it grants power to laws passed within a certain frame of time, even state laws, as being like constitutional doctrine, which just seems really weird.
That's crazy. This seems like a really interesting thing to ask him about, though, right? Because he's obviously willing to apply originalism to the time that all these amendments were written, but I wonder if he applies this not just to the Constitution, but to just random ordinary laws too. Like okay, Obamacare was passed in whatever it was, like 2014 or something. So should we take like the culture of America in 2014 and like use that as we're applying the Obamacare laws going forward or something?
Yeah. Man, yeah, this is really interesting to think about.
Policy perspective, I'm not assuming that you're in favor of school segregation when I bring that up. It's just to show you that like Brown v. Board is one of those seminal cases among others that I've mentioned where we think that we got it wrong. In fact, one of the I hope we'll get to start discussion at some point. One of the examples like we overturn stuff sometimes is pointing to Brown v. Board and Plessy. And so, like, I don't. Sure. If you're going to reject the notion that rights could exist beyond the circumstances, like, what you have to assume, taking your analysis, is whatever circumstances existed at the time of a particular amendment, 50, the majority, that must be allowed. by the Constitution. That's silly. That's not how we look at it. We look at what the Constitution was intended to mean in the sense of its value, in the sense of like, what is this actually doing? That's what Scalia is doing in the Kylo case and in the other cases related to, dogs sniffing your property for drugs. That's the act of, I mean, that is what it means to interpret law and to interpret the Constitution.
I'll go further. If the Fourth Amendment, at the time of drafting that Fourth Amendment, they said sometime in the future they're going to invent like heat sensors, and that should be allowed. That's like obviously like that should be something that we allow. I would say the Kylo case at that point would probably be wrongly decided, consistent with my argument the entire time.
Wait, can you repeat that? Sorry.
So if at the time of let's say the heat sensors existed at the time of the drafting of the Fourth Amendment, and like they were legalizing like heat sensors at the same time they were drafting the Fourth Amendment, I would say like Kylo would probably have been wrongly decided if the historical facts pointed to that being the case. Because obviously they didn't intend for that to be the case, and no reasonable historical analysis would lead people to believe that's what they meant. Unlike the current case in Kylo, which is we have a new technology. What would they like? What is this intended to apply to here? I mean, there's more room for analysis there, and I think that there simply is not when you have again a scenario where they're actively criminalizing something at the same time as they're passing this amendment.
Is it significant at all to you that these abortion laws didn't come into being until the mid 19th century?
They were coming into they were actively coming into play. Like I think you've already agreed
in the mid 19th century. The first one is within like 1820.
Sure.
And Connecticut was one of the first ones in 1820, and really
likely, yeah,
and really
before the 14th Amendment and before.
Yeah, so it doesn't matter what happened near the founding of the country.
I mean, clearly it wasn't very deeply rooted. If like they just all started switching it.
Well, you agree it's part of the common law.
Well,
or do you? I don't know.
Yeah. Well, sure. I mean, Alito has some analysis of like the common law. I sort of think that part's maybe a little bit weaker. I mean, we can talk about like quickening and stuff, but again,
this kind of underlies, I think, the problem with trying to have like, oh, this is what America in 1791 thought, or this is what America in 1864 thought, which is like, there is no answer to that. Like, we can talk like broad generalities and stuff, but you're never going to have like this cohesive opinion, and certainly not over some very divisive issues. And also speaks to like, Lactoid says, oh, it's not very deeply rooted. Well, hold on a second. How can you say that, how do we know that, this flare-up of anti-abortion activity isn't the exception to the historical rule? I could just as easily cast the light of, we see support for abortion in the common law before, at the time of the 14th Amendment, and now we see it now. Clearly, actually, the deep-rooted thing is the support for abortion. It's like, I think when you have this debate, both sides can just play the no true Scotsman fallacy back onto each other like a million times over. And it's really hard to actually sort out that question, I think.
Yeah, so like, let me see if I understand what you're saying correctly. Like if there's something that was going back and forth in the United States for a long time, or something that was really controversial, then in some sense, both sides of the argument have a claim to be deeply rooted, and therefore, like, the deeply rooted thing is not enough to decide between them. Is that kind of where you're going? What you mean by it?
Yeah, 100%. And it's also just, it's really hard to kind of try to evaluate like the idea of like a deeply rooted idea when America, especially not only when America only has a couple hundred years of history, but also when, we are still in the midst of this right now. Like, it's the thing I always say about like, the Republican Party and Donald Trump is it's like, it's hard for me to evaluate how truly bad the Donald Trump presidency was because we don't yet know what all its effects are going to be. We're still feeling them. Is Donald Trump going to be in control of the Republican Party in 10 years? If so, then the Donald Trump presidency will be like, will easily be like maybe the worst presidency in American history. But if not, well then okay, it's not the worst. It's only in like the bottom half. Then it starts to become a lot more malleable.
Yeah, well, and obviously there's endless historical debate about what the effects of any presidency are even like 100 years afterwards. But another thing I wanted to mention was one of them just used the word quickening. So this is a kind of like obsolete medical term having to do with the way that they used to look at abortions, or I'm sorry, not just abortions but pregnancies. Like basically what they believed was that that there was this event called quickening at which the fetus suddenly like came to life, and
Yep.
before that, it basically wasn't a living thing. And I think this is supposed to be like when the heartbeat starts, or something like that.
Yep.
But this presents kind of an interesting thing having to do with originalism as well, because if you're saying we should just interpret every law in an originalist framework, like what about things that the original founders were just flatly wrong about? And I don't just mean like morally we disagree with them, like slavery or something like that. I mean just like they scientifically misunderstood things, right?
Yep.
I mean, I can't think of a law off the top of my head where something like that would matter, but it's not inconceivable that there could be a law that's just completely based on some 19th century
Hmm.
understanding of physics or chemistry or something like that.
Yeah.
So are we then supposed to go back to their like scientific misinterpretation of what was happening
Yeah, the
when we
question
interpret?
is, what is the value in? I think the thing that Peace can kind of go after here is what is the value in grounding our understand in grounding our constitutionality in what the founders like believed. Because and where do we say that that value has gone too far? Where do we say, okay, we know the founders absolutely like the question is like earlier Lactoid said, what if hypothetically it was the case that the passage of the 14th Amendment explicitly said this does not apply to abortion? Because it was like, well, that would make it a much harder argument. What scenario would it make it? Is there any scenario where the constitutionality should give way to what we know they meant and really what we think would be better for the Constitution to have? Because, theoretically, you would say that, oh, that's like the reforming process, right? Someone like that would say, well, that's what the purpose for, like the constitutional amendments is, or a constitutional convention. But I think like the my response to that would be like, let's imagine a world. Right, even that is still within the framework of what is useful to us. Because let's imagine a world where the Constitution was tyrannical inherently and it had no amendment process. Well, then I think, and you can get points among, more conservative people like Lactoid from this. You would say, at that point, revolution becomes your obligation, right? I believe there's a Thomas Jefferson quote about this.
Hmm.
Um, and I think you could make a real appeal that, like, hey, the function of our Constitution is always going to be in favor the function of a constitution exists to get us good things, right? To get us liberty and freedom and to enshrine those things. And
Right.
so I think we can then make certain allowances where we're like, oh man, we could try and go through the whole rigmarole of constitutional convention to ratify the idea that like black people are equal to white people, or we could just have a constant like we could just have like a decision here that is we could have like a Brown v. Board decision and like sure maybe it's not rock solid, but I mean the Constitution isn't rock solid. It's full of weird contradictions and things like these, and it's okay to do like a 1% compromise on like the legal logical consistency of the Constitution if it means we get big gains elsewhere. We are all willing to sacrifice a certain amount of freedom for a certain amount of security. It's just a question of that ratio.
Yeah. Yeah, I had a couple of things I wanted to say to you. Okay, so for one thing, you were saying imagine a world where the Constitution is tyrannical and there's no amendment process, there's no like legal recourse to do it. But I think you could say that even with the amendment process, the Constitution still can be tyrannical even
Yeah.
then, right?
Oh
So
yeah.
for example, the whole slavery thing, right? I mean, the slavery issue was not able to be resolved within the constitutional framework despite the fact that the amendment process did exist at the time, right?
Yep.
It's just the amendment process is such a big hurdle that they weren't able to overcome it, and therefore this tyrannical system did persist for
Yeah.
um
In a certain light, you're almost like, thank God the South seceded, because in those years where the South had no political representation, we were able to just ram through all this stuff that otherwise probably would have been dragged out for a decades. I mean, probably well into the 20th century if you look at how long it took us to get rid of Jim Crow and like how long the Dixiecrats remained a real political force.
I always wonder about the legality of that stuff because, like, even though the South seceded, I think the North still considered those southern states to be legally part of the
Yes.
United States,
Yes,
even.
they consider them areas in rebellion, which is then like, okay, I mean, Lincoln bended the Constitution pretty badly in certain cases, and he was right to do so because extreme times call for extreme actions. In the same way that during World War, the draft. I don't think anybody here would say the draft. The vast majority of people would admit that the draft is kind of like a violation of rights. But like, listen, man, if it's the draft or like the existence of our country, like we're gonna do the draft.
Yeah. I wonder if somebody like Lactoid would agree that something like the draft or the stuff that Lincoln did was right. I mean,
Or even a more pertinent example, like what FDR did during World War II. Set aside things like the Japanese internment camps, which arguably he didn't need to do to succeed. What about the fact that the government just said to a lot of like car manufacturers and industrialists, hey, you are just going to start making our tanks now because we need the entire country. There were tons of arguably pretty potentially even Orwellian measures in terms of like rationing like gasoline and forcing people to be more efficient in their resources and stuff. Because they needed the absolute optimal output of the country's industrial capacity, which included private entities.
Yeah. Interesting that you bring up the Japanese internment camps because having seen part of this conversation before, I do remember that is one of the things that they talk about, and I think we haven't gotten there yet, but they are going to be talking about that Japanese internment camp case. Something else you said earlier reminded me back to the like textualism versus originalism thing, right? I can't I forget exactly what it was that you said, but it was something like even if the founders obviously meant this one thing, but that's different from what the text says, then which of those two things should take precedent according to well, I mean, I would imagine that different people are going to disagree on that issue, but Lactoid seems to be primarily framing his constitutional view in terms of originalism rather than textualism. But I wonder like what he would say to like
Yeah, I
when those two
wonder.
conflict.
Yeah, because I wonder if Lactoid would say, well, actually, that's just the point. It is because, because earlier I said, oh, Lactoid, people interpret things lots of different ways, but we can agree there's like a real consistency. I wonder if Lactoid would say, no, 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 no. That's my point, that there really isn't that much of a consistency. So that our position of the Constitution should be do not do as I say, do as I do. Because we will never have, like Lactoid would say, we ought not set up a framework in which we interpret the Constitution based off of what the writer said, because that is so unreliable. Instead, we should use the much more reliable metric of their actions, that is not a flaw in my argument. That's actually at its core.
Yeah, I think it would actually be like pretty hard to argue that that's more reliable than the text.
Yeah, I think because I think there's a lot of problems with that. But it's just I'm curious what he would respond to that question with.
Yeah.
Again, I don't think that.
Oh, sorry. Actually, just as a heads up, I'm gonna have to head out at about the top of the hour.
Oh yeah. Cool. That's fine. And then we can maybe like do research this week and then review the second half of the video next week. Does that sound good?
Yeah.
Okay.
Yeah.
Apply to like when we're talking about at the time the amendment was drafted. I think that is much more controlling than like common law going back to Britain about
that's nice, right?
a scientific misunderstanding
Okay, great.
of like when movement begins,
So
because the current evidence shows that like fetal movement begins at about 6 weeks. At the time, the mother could only feel it at like 16 weeks. So like, oh, that's obviously like when the baby starts moving, but that's just like scientifically incorrect.
I think it's pretty ad hoc the way you use his history. Like the history that you care about is the only history that matters. I'll throw you one for the Second Amendment. Around the time of the 14th Amendment, you would agree the Second Amendment does not apply to the states until the 14th Amendment, correct?
Like I'll have to double check that, but I'll take your word for it. That's my understanding of what I think is the case.
Well, it was just recently incorporated as applied to the states in 2010,
right?
In the McDonald case. But my
right.
question for you is like, if there were evidence of state laws which totally banned the usage of like arms in public, or banned the public carrying or even concealed carry at the time of the 14th Amendment was passed, you would agree that the Second Amendment should be interpreted in such a way to not embrace an individual right to concealed carry or public open carry in public, right? If there was evidence of those
follow
laws
that
being
question. Can we back up a few seconds and listen to it again?
Yeah, I'm also not really understanding here. Let me go 40 seconds here.
My understanding of what I think is the case.
Well, it was just recently incorporated as applied to the states in 2010,
right?
In the McDonald case. But my
Right.
question for you is like, if there were evidence of state laws which totally banned the usage of like arms in public, or sorry, banned the public carrying or even concealed carry at the time of the 14th Amendment was passed, you would agree that the Second Amendment should be interpreted in such a way to not embrace an individual right to concealed carry or public open carry in public, right?
Okay, I followed it this time.
If there was evidence of those laws being in place in, say, Texas or New York.
No, I think a better understanding would be like if while drafting the 14th Amendment, they all said, like maybe even if they didn't put it in, if they all said like, yeah, this probably shouldn't apply to the Second Amendment, and at the same time, like they were criminalizing criminalizing gun laws. Yeah, I guess you could probably like look at that, just as whether or not gun. The only problem is there now we're talking about like a state by state basis as opposed to like a federal sort of overarching amendment. I'll have to think about that a little bit more, but likely, I think the logic stands where if you have somebody doing something at the time of drafting, you have somebody criminalizing something, it's generally probably a safe assumption they don't mean for that to be like incorporated in with the amendment that they're creating. Likely.
And I think it's a generally safe assumption that at the time of the passage of the 14th Amendment, we didn't think that we were going to be applying every single right to the states. And so I don't understand why you're okay with those implied rights if there's nothing explicit in the Constitution which says that you can apply them to the states. You're reading them into it and into like what the value is of the 14th Amendment. You're saying that the 14th Amendment was meant to bring the states into a common kind of like, I don't know, stature with the federal government to put people on even
with the Bill of Rights. I think so.
Okay, but you haven't pointed to anything specific. Like, at least I'm not asking you for like specific quotes. I'm not asking you for specific things. Like, what's the kind of historical evidence that you would point to show that there was an intent to incorporate the Bill of Rights at the time the 14th Amendment was passed?
Historical activities at the time, the certain laws that were being passed in the states, like the intent of the federal government post Civil War, what they were doing to the states in the South. I think there's like all the Reconstruction, like there's all sorts of things that like you can look at, like, yeah, like this was meant to apply to that, obviously, and they weren't actively contradicting it like they were like in the 14th Amendment when it comes to abortion. Like if they were actively contradicting it, because if they were like if they were at the same time they're passing the 14th Amendment, they were also passing legislation saying like federal legislation saying like this like, the Bill of Rights does not apply to like the states.
No.
Like then obviously it wouldn't.
Well, there are all kinds of challenges. There were all kinds of challenges early on, or late on in the 19th century about the Bill of Rights applying, and it wasn't really until the 20th century that you're seeing these cases start to be applied as against the states. I don't know. I don't think the common practice was back in after the passage of the 14th Amendment to acknowledge that the federal constitution had been incorporated to apply to the states. And what you're doing right now, which is like saying, what was the purpose of the 14th Amendment? I totally agree with that analysis. That's a great analysis. Like the 14th Amendment was meant to bring these states into the fold, to give a more baseline
at the time of creation. Yes.
Yeah, but
3 years after the Civil War.
But that was also that is the kind of analysis we're looking at the purposes of the 14th Amendment and what it meant at a higher level of generality than any particular set of circumstance.
Yeah, I again, I disagree. But I also think this is somewhat of a dead horse because I've explained my logic. One, we're closing in when it comes to time, but I want to hear your because stare decisis I know is one of your major points, and I wanted to give you an opportunity.
I was thinking I've only got like 5 or so more minutes. I think this might actually be a good point to pause if they're putting a bookmark here and then moving to a separate point.
Yeah, sure. So just to remind everybody who didn't see the beginning of the stream, we are doing a 2-part stream where we're first listening to a bunch of legal arguments as laymen. Then we're going to, over the following week, we're going to go do a bunch of research off stream. Then we're going to come back and do the second half of the review of this video, having done a bunch of reading already, and we're going to see like if that changed our perspective or if we learned anything from it. Yeah, so Flowtrace, do you want to shout yourself out or anything before we're done?
Yeah. Hey guys, my name is Flowtrace. Thank you guys for watching. I'll be here next Wednesday. You can also find me on twitch.tv/Flowtrace, twitter.com/Flowtrace_, and you can find me on a lot of Twitch politics panels. And you can also find me every Wednesday on twitch.tv/CricketStyleJ.
All right. Thank you very much for joining me, and I'm gonna go ahead and raid into somebody online.
All right, I'll see you, man.
All right. See you later.